அதான் எம்ஏ ஐயங்கார் வாழ்க்கை
இப்போ அவருக்கு செப்பரேட்டா
ஹண்ட்ரடா சரி அது ரிமூவ்
ஒரு 5,4 அர்ஜுன் இன்னைக்கு
5,000
ஆமா அவருக்கு நம்மளால நாங்கள் ஏதோ ஒரு புது வேண்டியது
ஓகே
இந்த சேவைலாம் பண்ண வச்சாரு அதுக்கு மறந்தே போயிட்டோம் அவரோட
சரி.
இவர் யாரோ ஒருத்தர் சொன்னாரு My lord's kind leave, that's all.
Ah.
With my lord's kind leave, that's all.
Ah.
Mr. Aditya is not in town today. So hearing matters.
Which one?
Hearing matters, Mulad Zara. I'm sorry, there are more than 5 matters.
Not well.
Aditya or illa uralde. So
All.
I need
Call
some
next
accommodation.
Next week, Marana.
I'll give the numbers to
Okay.
Mulad.
My lord,
Ah,
serial number 25, I have informed the respondent just a
25?
week's time, 25 minute, last
Ah.
minute.
I appeal for the respondent.
It may be taken up week after next.
all. This week after next, at the request of
Your
Ah.
Lordships, serial number 15, your lordships.
1-5.
Yes, seeking for an adjournment, your lordships. Kind
ಮತ್ತೆ ಎಲ್ಲ ಅಜರ್ ಮಾಡ್ಬಿಟ್ರಿ ಏನ್ ನಾವು ಕೆಲಸ ಮಾಡೋದು ಹೆಂಗೆ? All right.
apologies. Your Lordship.
Week after next.
Oh,
Your Lordship, sincere apologies. Senior has undergone a medical injury. Serial number 14, Your Lordship.
1-4.
Please, Your Lordship.
Unni Krishnan.
Mahesh Chaudhary, Your Lordship.
Mahesh Chaudhary has undergone not well.
No, please, Your Lordship. He has injured his foot, Your Lordship.
Oh, call after 2 weeks.
14 and 22, Your
All
Lordship.
right, 14 and 22.
Grateful, Your Lordship.
Convey my wish for speediest recovery.
Please, Your Lordship. Grateful.
Okay. Yes. ಎಲ್ಲ ಲಾಯರ್ಸ್ ಸ್ವಲ್ಪ ಹೆಲ್ತ್ ಕಡೆ ಗಮನ ಕೊಟ್ಕೋಬೇಕು. ತುಂಬಾ ರಿಪೋರ್ಟ್ಸ್ ಆಗ್ತಾ ಇದೆ, ಬಹಳ ಟೆನ್ಷನ್ ಮಾಡ್ಕೋತೀರಿ, ಆಮೇಲೆ ಓಡಿ ಬರೋದು ಏನು ಅಂಥದ್ದೇನಾಗ್ತಿರ್ತದೆ, ಓಡಿ ಬರ್ಲಿಕ್ಕೆ ಯಾರನ್ನ ಹೆಂಗ್ ಮಾಡ್ತಿರ್ತಾರ. ಸ್ವಲ್ಪ ಸಮಾಧಾನವಾಗಿ ಬಂದ್ಕೊಡಿ. ಯಾರಾದ್ರೂ ಒಂದು ಏನು ಪಾಸ್ ಓವರ್ ಮಾಡ್ತಾರೆ, ಇದನ್ನ ಮಾಡ್ತಾರೆ.
ಇಲ್ಲಿ ನೋಡಿ ಶಂಕರ್ ಇದ್ದಾರೆ, 20
ಹಾ.
ಕಿಲೋಮೀಟರ್ ಓಡ್ತಾರೆ.
ಹಾ
20 ಕಿಲೋಮೀಟರ್.
ನೋಡಿ.
33 kilometers, sir.
My
My lord, my friend, I am correcting my friend.
he walks. He's a
ಹೌದು.
walking encyclopedia of at least taxation law. Yes.
Here for respondent.
ಹಾ ಏನು?
Appellant has to file some documents, synopsis.
Appellant
may-
has to file a document.
Synopsis of the order. Your lordship, it may be dispensed with, my lord, for time being, my lord.
Yes, dispensed with. 2013 matter. First, we'll start.
Please, my lord. Next week, it is challenging the constitution validity, my lord.
ಯಾವುದು ಯಾರು ಎಲ್ಲಿದ್ದಾರೆ ಅವರು?
Seal number 1.
2013.
My lord, I am appearing for it.
ಹಾ.
Your lordship may fix a date, we'll argue, ready for arguments, my lord. Only thing, Raviraj told me that he's not there today and he had requested me that we will do it next week on account of his Kumbh travel. So your lordship may fix any day convenient to your lordship after 13th, my lord.
ನೋಡಿ 13th ಆಗ ಡೇಟ್ ಕೊಡಿ. 18th. ಫೈನಲಿ 18th ಮಾಡ್ಬೋದಾ ಶಂಕರ್?
18th better, my lord. 20th, my lord, because 18,
sorry.
19 Supreme Court matter is there, my lord.
All 20th. Okay.
Seal number
Yes.
2, Sanmati.
Your
My
lordship,
lord, this matter can be disposed of as under the ground of monetary limits. I have given the copy of the circular to Sanmati, my lord.
Your lordship, liberty may be reserved to the revenue to seek for revival if in case it falls under exception clause mentioned in instruction 5 of 24.
How, otherwise you tell now only.
I know,
What
because,
liberty na?
I
Revive
don't-
ಮಾಡ್ಲಿಕ್ಕೆ.
I don't have that
But,
information.
my lord, there is nothing to worry, my lord. This is a standard thing that they ask for because some officer may ask them.
Be on
So your
safer
lordship
side.
may
That
grant it.
we-
I am very confident that none of the exceptions arises. So your lordship may consider
No, no,
giving.
Disposed of as not maintainable in view of
Your lordship, 9 of 24. my
the
lord.
monetary limit prescribed in CBDT circular 9 of
24, my lord.
2024.
And the
Subject
money,
to all just exceptions.
Subject to, your lordship, liberty may be reserved to if the case falls under exception circular number 5 of 24.
Liberty is reserved to seek revival if it is otherwise maintainable. Okay.
If it is
Lordship.
if the case falls under exception shown in
ಅದಕ್ಕೆ otherwise maintainable
5 of 24. ಅಂತ.
by way of exception. Okay. OL ಅನ್ನ ಇಂಪ್ಲೀಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ರೆ ಈಗ ಯಾವ
ಅದು
ಪ್ರಶ್ನೆ
ಹೇಳಿದ್ವಿ,
ಬರುತ್ತೆ?
because if it is disposed of, my lord,
That's
there is no need of
Okay.
that.
Disposed of.
It may be disposed of.
Seal number 3, EI Sanmati.
Lordship, connected matters, delay has been condoned, my lord.
ಎಷ್ಟಿದೆ ಡಿಲೇ?
Arising order of the common order, my lord, your lordship has condoned the delay.
ಬುಕ್ಸ್ ಕೊಡಿ. ಕಂಡೋನ್ ಮಾಡೋಣ, ಬುಕ್ಸ್ ಕೊಡ್ಲೇಬೇಕು.
My
Books ಅಷ್ಟೇ condone
objections may
ಮಾಡಲ್ಲ.
be recorded.
ಆ?
Delay may be condoned, but my objections
Your
may be
objections will be very much noted. ಬರ್ಕೊಳ್ಳಿ ನೋಡಮ್ಮ. ಸಬ್ಜೆಕ್ಟ್ ಟು ಪ್ರೆಸೆಂಟಿಂಗ್ ಯಾವ ಪುಸ್ತಕ?
Karvalo's Purnachandra Tejasvi, my lord.
ಅದನ್ನ ಈಗಾಗಲೇ ಮಾಡಿದ್ದೇವೆ ನಾವು. ಅವ್ರದ್ದು ಜುಗಾರಿ ಕ್ರಾಸ್ ಕೊಡಿ ಅವ್ರದ್ದೇ.
Please, my lord.
ಜುಗಾರಿ ಕ್ರಾಸ್ 5 ಕಾಪಿ ಕೊಡಬೇಕು.
Yes.
5 ಚಿಕ್ಕದು ಸಣ್ಣ ನಾವೆಲ್ಲ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ನಾವೆಲ್ಲ ಜುಗಾರಿ ಕ್ರಾಸ್ ಬೈ
ಲೈಬ್ರರಿಗೆ 2 ಸಾಕು.
ಸುಮ್ಮನೆ ಲೈಬ್ರರಿಗೆ ಕಾರ್ಡಜೋ ಗೇವ್ ಹೋಲ್ ಆಫ್ ಹಿಸ್ ಪ್ರಾಪರ್ಟಿ ಟು ಕೊಲಂಬಿಯಾ ಯೂನಿವರ್ಸಿಟಿ. ಎಸ್ ಹೇಳಿ ವಿಲ್ಗಳು ಇಲ್ಲೇ ಇದ್ದಾರೆ. ಕಾರ್ಡಜೋಸ್, ಇಫ್ ಯು ರೀಡ್ ಎನಿ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಬುಕ್ ಆನ್ ಕಾರ್ಡಜೋಸ್ ಬಯೋಗ್ರಫಿ ಯು ವಿಲ್ ಫೈಂಡ್ ಇಟ್ ಆಸ್ ಎ ಚಾಪ್ಟರ್. He gave whole of his library to Columbia University. ನಾವೆಲ್ಲ ಎಷ್ಟು ಕೊಡ್ತೀವಿ? 2 ಪುಸ್ತಕ ಕೊಡ್ಲಿಕ್ಕೆ ಅಳ್ತಾ ಇದ್ದೀವಿ. ನಾವು ಹಂಗೆ ಏನೇನೋ ಹೇಳ್ತೇವೆ, ನಾವೇನು ಕೊಡೋರಲ್ಲ ಮಾಡೋರಲ್ಲ.
ಇಲ್ಲ, connected
Library ಬೆಳೆ-
ಬ್ಯಾಚ್ ಇದು, ಅದ್ರಲ್ಲಿ ಆಲ್ರೆಡಿ ಸುಮಾರು ಆರ್ಡರ್ ಆಗಿದೆ ಅಷ್ಟೇ.
ಕೊಡ್ರಿ, ಇನ್ಮೇಲೆ ಸ್ವಲ್ಪ ಓದೋರ್ನು ಕೊಡ್ಬೇಕಾಗ್ತದೆ. ಮೋಸ್ಟ್ಲಿ ಬರೀ ಬುಕ್ಸ್ ಕೊಟ್ರಾಗಲ್ಲ. ಯಾಕಂದ್ರೆ ಬುಕ್ಸ್ ಅನ್ನು ಯಾರು ಅವು ತಬ್ಬಲಿ ಆಗ್ತಾ ಇದಾವೆ. ಅನೇಕ ಪುಸ್ತಕಗಳು ತಬ್ಬಲಿ ಆಗ್ತಾ ಇದಾವೆ. 1993 ಒಂದು ಬುಕ್ ಬಂದಿದೆ ನಮ್ಮ ಹೈಕೋರ್ಟಿಗೆ. ಅದು ಕಾಜೇಷನ್ ಇನ್ ದ ಲಾ ಬೈ HLA ಹಾರ್ಟ್ ಅಂಡ್ ಟೋನಿ ಹೋನೋರ್. ಮೊನ್ನೆ ಅದು ಬೇಕಿತ್ತು, ನಾನು ಅದನ್ನ ತರಿಸಿದೆ. ನಾನು ಐ ಆಮ್ ದ ಫಸ್ಟ್ ಪರ್ಸನ್ ಟು ರೀಡ್ ದ್ಯಾಟ್. ನಂದೊಂದೇ ಹೆಸರಿದೆ ಅದರಲ್ಲಿ 93 ಇಲ್ಲಿವರೆಗೆ. ಅಂದ್ರೆ ನಾವು ಸ್ವಲ್ಪ ಪುಸ್ತಕದ ಕಡೆ ಗಮನ ಹರಿಸ್ಬೇಕು, ಎಲ್ಲ ಓದಿ ಮಾಡಬೇಕು. ಎನಿವೆ, ಇದು ಯಂಗ್ಸ್ಟರ್ಸಿಗೆ ಮಾತು. ಎಲ್ಡರ್ಸ್ ಎಲ್ಲರೂ ಓದೇ ಓದ್ತಾರೆ. ಫಾರ್ ಯಂಗ್ಸ್ಟರ್ಸ್ ಐ ಆಮ್ ಸೇಯಿಂಗ್ ದಿಸ್. ಎಸ್, ಬಡಿ 5 ಪುಸ್ತಕ ಒಂದು ಗೌಡಿಗೂ ಕೊಡಬೇಕು.
Yes, please.
ನೆಕ್ಸ್ಟ್
Seal number
This-
4,
My lords, this can be tagged with the other matters.
ಕಾಲ್ ಅಲಾಂಗ್ ವಿತ್
ITA
ನಂಬರ್
683 of 2020.
ಅದು ಕಾಲ್ ಅಲಾಂಗ್ ವಿತ್ ಇಫ್ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಟ್ಸ್ ಕಂಪ್ಲೈಡ್ ವಿತ್. ಓಕೆ,
Number 5. Vishal Tiwari. Sorry.
Your Lordship, for 1 week time may be granted.
Yes, Sanmati, C number 5.
Third time.
Your Lordship, first time before this honorable court, my lord.
ಹಾ.
ಅದು ಈ first twice ಅಲ್ಲಿ ಬಂದಿರ.
1 week, 2 weeks, final. Next time heavy cost will be imposed. Okay.
C number 6, YV Raviraj.
Your Lordship, in the copies are legible, my lord.
Eligible.
Illegible because those are the seized materials, my lord, the extraction of that. It is
Submission
not.
of panel counsel accepted and of its objection for the time being is overruled. ಏನಲ್ಲ complaint number.
That one I will complain now only, my lord. ಒಂದು
Fine.
ಹೆಸರು ಬರಿಬೇಕಷ್ಟೇ.
Good. ತೊಳಿ ಮಾಡಿಕೊಡಿ. ಏನ್ questions ಏನು?
Your Lordship, it may be posted for admission, my lord.
All right. Post for admission. ಅಲ್ಲಿ other requirement is complied with ಅಂತ ಹೇಳ್ತಾರೆ.
Yes, my lord.
C number 7, Chandrasekhar V.
Chandrasekhar
My lords,
V.
appearing for the appellant in this matter, my lords. Ready
Ah.
for 1 week time to comply with the office objection. My lord.
Give
I'll
one
comply
good
within a
book.
week, my
We'll
lord.
give you 2 weeks. Don't worry. We'll give you 2 weeks. Now third time it has come. ಒಂದು ಒಳ್ಳೆ ಯಾವ್ದಾರ
My
ಒಂದು ಒಳ್ಳೆ ಪುಸ್ತಕ ಕೊಡಿ.
Karunalu Ba Belako, my lord, by Dr. Guru Raj Karjige.
My
Corona.
friends have already decided what to ask your lordship. They are keeping the book's name ready, my lord.
Karunalu Ba Belako, my lord.
ಕರುಣಾಳು ಬಾ ಬೆಳಕೆ. Okay. There is a
Yes, ma'am.
Newman's famous poem, Lead Kindly Light, which is translated by B.M. Shri as ಕರುಣಾಳು ಬಾ ಬೆಳಕೆ. Okay. ಕೊಡಿ.
Yes,
ಕರ್ಜಿಗೆ
ma'am.
ಕೊಡಿ. ಗುರುರಾಜ್ ಕರ್ಜಿಗೆ. Good.
Yes, my lord.
ರಾಮ. ಐದು
My
ಕಾಪಿ
lord,
ಕೊಡ್ಬೇಕು.
My lord, my juniors are always deciding the book to be purchased in the morning, my lord. I asked them what it is. They are deciding what are the good books. I said one day Kannada, one day English, it seems, my lord.
Anyway, I can
Good, my
prescribe
lord. At
Sanskrit
least they are
books
buying one
also.
copy to the office and they are reading also.
At least ಅದು ಯಾರು ಒಬ್ರು ಓದ್ತಾರೆ. ಏನೋ ಒಂದಾಗ್ತದೆ.
Yes, my lord. Yes, my lord.
Yes.
Book is something which is very dear to all of us
That's it.
at our generation.
C number 8.
Say number 8, my lords, respondent has filed application for vacating stay.
Ah.
It's, my lords had stayed,
Submission, my lord.
it's just one submission, my lords. I have some 1 day's accommodation, my lords. I'll file
Just make
application
one
for vacating
submission,
stay. The
My lord,
reason
we have
I'm,
filed a caveat. What they have done, my lord, is they have challenged the order of the honorable arbitrator.
ಅವ್ರಿಗೇನೋ ಒಂದ್ ದಿವಸ ಟೈಮ್ ಬೇಕು ಅಂತ.
No.
One
what I
day's time,
submitted-
my
I
lords.
just want, with my learned friends. We had filed a caveat, my lord. As regards to the very same order, my learned friend had orally made a submission, what I understand, that the caveat does not pertain to the writ petition, which is placed before my lords. My lords was pleased to say that the objections are overruled and was pleased to pass an interim order granted in their favor, and emergent notice was also issued.
ಅಲ್ಲ, he wants 1 day time.
No.
You want to argue?
No, I just want to place what the honorable arbitrator has requested to place before my lords. That's all, because this was given to me to place before my lords. That's all.
ಕೊಡಿ. ಸರಿಯಾಗಿ ಸ್ವಲ್ಪ ಸ್ಟಿಚ್ ಮಾಡಿ ಇದನ್ನ ಮಾಡಿ.
No, I didn't want to stitch, my lord, because there's a check.
yes, I think he is
That's
giving
why-
as given by the arbitrator. I believe.
That's why even the envelope, I've given it as it is. Yes. The same.
ಇದು 3 ಲಕ್ಷ ರೂಪಾಯಿ ಚೆಕ್ ಇದೆಯಾ?
Yes, my lord.
ಏನ್ ಮಾಡ್ಬೇಕು ನಾವು ಅದನ್ನೀಗ?
My lord, it is, they have, my lord, the claimant before the arbitral tribunal had remitted this check through a third party, which the arbitral tribunal was wanting to return the check to that third party. Therefore, the check is in
ನಾಳೆ ಕೊಡಿ, ಅವ್ರು ಬಂದಾಗ್ಯದ.
tomorrow, my lord. Tomorrow, my lord.
Tomorrow.
Please, my lord.
Tomorrow ಆಗಲ್ಲ, Monday.
Monday, my lord.
Intimate to continue till next date of hearing.
Preliminary matter, C number 9, government advocate.
For short accommodation.
He's not there, no? Mr. Bhatt is not there. Inform me, could I request the week commencing 17th, 18th could be after 16th, any date after 16th?
Not
18.
18th.
ಹಾಕ್ಬೋದಾ?
18th.
Okay. Entry ಮಾಡಿದೆ ಏನು?
ಇಲ್ಲ.
ಇಲ್ಲ.
Number 10, will be Chavan.
Yes, Mr. Chavan.
My lord, this matter pertains to the issue of that common show cause notice for multiple financial periods, my lord. Your lordship had
There was some Madras
Yes.
High Court judgment, no?
Madras High Court judgment. These are the list of
List
other
of matters.
My learned friend.
I'll take another. You appear for, this is the list.
This is the list, my lord.
Call along with.
These are all the same.
Call along with. madam.
Please.
ಯಾವಾಗ ಬೇಕು?
Week after next, it can be called.
Ah.
Because it is just one issue, if it has to be decided.
Okay. No other High Court has taken the contrary view?
My lord, Madras High Court has taken the view, my lord. Kerala High Court has taken contrary view. Madras High Court matter has been now appealed. It is pending in writ appeal.
Okay.
That's all.
Call, ನೋಡಿ, call along with these things. Some data about it. 2 weeks, 2 weeks. Please, get the request now.
For further hearing, scene number 11,
First petitioner,
Ashok Kumar. Arjun.
petitioners. Yesterday's matter.
Correct. Correct.
Right, your lordship's concern, lord, and suggestion was taken, but there's some feeling in the mind of our client that injustice has been done to him. And when there's such a feeling, my lord,
You
I
have to
think it's very difficult to persuade
Yes.
someone
No,
as to what is
we
to be
only
done.
suggested.
Yeah, no, my lordship says, I do our duty, my lord, to try and persuade them. But we'll argue it, my lord. Lordships may then take a decision on
Yes.
what is
Good.
appropriate
Yes.
in this case. But there's one small additional statement which we are filing has, my lord, actually as to why that price.
ಒಂದು
Yes.
ನಾವೇನೀಗ ಅಮೌಂಟ್ ಕೊಡಬೇಕು ಅಂತ ಮಾಡಿದ್ವಲ್ಲ,
ಹೌದು.
ಆ ಅಮೌಂಟ್ ಕೊಡಲ್ಲ ನಾವು. Hearing,
No.
merit ಮೇಲೆ ಮಾಡಿ.
Of course, my lord, on merits your lordships will examine.
Okay.
If I'm right, my lord, maybe I'll succeed and
No, no,
retain the
that's all right.
property.
If you succeed, well and good.
Otherwise, my lord, of course, there'll be some consequence which may follow. We quite see, my lord, what the lordship has said.
Okay.
Lord, of course, the issue comes down to probably just one. And as to whether the negotiation and finalization of the sale with the second highest bidder is proper or not.
Correct.
And
In view of 9.3.
in view of Rule 9,
9.3.
but I want your lordships also to look at a few other regulations in the security interest rules to see as to, my lord, what are the options available with the secure creditor who wishes to dispose of the property in exercise of his powers under the Securitization Act. Can I request, my lord, can I take the security interest rules? my lord?
Secretary. Surfacing.
Rules, security interest rules.
Security interest rules.
Yeah.
I had read one commentary on identical point by T.R. Andharujina. T.R. Andharujinadu ನಮ್ಮ ಲೈಬ್ರರಿಯಲ್ಲಿ ಇತ್ತು, ಓಲ್ಡ್ ಬುಕ್ ಇತ್ತು. T.R. Andharujina was a great guy of banking.
But like your lordship said, I was listening.
Uh.
Sometimes when you ask the book, your lordship will be the only one who's read it. So,
ಇತ್ತು, ನಮ್ಮ ಲೈಬ್ರರಿಯಲ್ಲಿ ಇತ್ತು.
Lord, can I request you not to kindly come to Rule 8 of the security interest rules?
Rule 8. Sale of immovable.
Sale of immovable secured assets. Where the secured asset is an immovable property, authorized officer shall take or cause to be taken possession. This is for taking possession.
Correct.
Then, my lord, please come to Rule 8.4.
Take steps
That
for
is
preservation
and protection. Then 5. Before effecting sale of the immovable property referred to in sub-rule 1 of Rule 9, authorized officer shall obtain valuation of the property from an approved valuer and in consultation with the secure creditor, fix the reserve price of the property and may sell the whole or any part of such immovable secured assets by any of the following methods. 1. By obtaining quotations from persons dealing with similar secured assets or otherwise interested in buying the assets. B. By inviting tenders from the public. C. By holding public auction, including through e-auction mode. Or D. By private treaty. Provided that in the case of removals, Jammu and Kashmir removal.
That will not apply.
Then, my lord, may kindly see 8. Sale by any methods other than public auction or public tender shall be on such terms as may be settled between the secure creditor and the proposed purchaser in writing. Therefore, there are a host of methods which can be employed by a secure creditor in order to dispose of a secured asset.
Yes.
Rule 9, my lord, provides for one of those mechanisms. Rule 9, may I just take your lordship's rule 9 very quickly, man? No sale of immovable property under these rules, in first instance, shall take place before the expiry of 30 days from the date on which the public notice of sale is published in newspapers as referred to in the proviso to sub-rule 6 of Rule 8, or notice of sale has been served to the borrower. Provided further, if sale of immovable property by any of the methods specified by sub-rule 5 or Rule 8 fails and sale is required to be conducted again, the authorized officer shall serve, affix and publish notice of sale of not less than 15 days to the borrower for any subsequent sale. Sale shall be confirmed in favor of the purchaser who has offered the highest sale price in his bid or tender or quotation, or offered to the authorized officer, shall be subject to confirmation by the secure creditor, provided that no sale under this rule shall be confirmed if the amount is less than the reserve price. Then the next proviso is, fails to obtain a price higher than the reserve price, he may, with the consent of the borrower and the secure creditor, effect the sale at such price. On every sale of immovable property, the purchaser shall immediately, that is on the same day or not later than the next working day, as the case may be, deposit of 25% of the amount of the sale price, which is inclusive of earnest money deposited, if any, to the authorized officer, conducting the sale, and in default of such deposit, the property shall be sold again. That, my lord, is where they now say it should be sold again, and therefore they say it should always be by public auction. My respectful submission, my lord, it need not be by public auction.
It need not be auction.
Need not be by public auction, because Rule 8 provides for the mechanisms by which sale can be effected. And in this case, the terms of the auction purchase or the rules for the tendering prescribed a mechanism by which, if it fails, I'm entitled to discuss with the second lowest bidder and negotiate and fix the price.
But that has not happened.
It has happened.
Negotiation happened.
Yes, yes. That is how, my lord, I came and I offered initially the same price as they did. But then when we went to the property, we found, my lord, a significant portion of the property had already been acquired by the government, which was not disclosed in the sale notice. Therefore, there was negotiation, and then 11.2 crores was fixed. That, my lord, is, in my humble submission, the distinguishing feature which I want to place before my lord in saying, now I want your lordships to kindly see the terms of the auction. Along with our objection statement, we have filed it. The first objections, my lord. The additional objections is what we filed now to explain one aspect. May I request, my lord, to kindly come in the objection statement, my lord, filed by us to page 35.
Objection.
Statement of objections.
Written submissions.
That's
Objections
filed by me, my lord. That's by me. They have filed objection there.
Objection statement. What if?
Objections filed by us.
28.
28.
ಈ ಕೊಟ್ಟಿದ್ದ
ಅಲ್ಲ ಇವಾಗ ಕೊಟ್ಟಿದ್ದು, this is the additional statement.
Objection statement ಇಲ್ಲ ಆಯ್ತು. 1 and 2.
Yes, my lord. 1 and 2.
Okay. Objections 1 and 2.
Yes. Can I request, my lord, to kindly come
Page number?
to page number 32, 33, which is the terms and conditions of invitation of sale.
33.
30, yes, 33. I would request your lordship straightaway to come to para 14. I don't know if my lord just got that.
Para 14.
At 35.
You're right.
I don't know if my Lord Justice Basraj got it. Successful bid.
The successful
Yes.
bidders.
Yes, ma'am. Shall be required to pay minimum 25% of the aggregate of offer amount in favor of asset reconstruction company upon being declared as a successful bidder, and the balance 75% of the purchase consideration within 15 days from the date of confirmation of sale or such extended period as may be agreed upon. In the event of any default in the payment of purchase consideration in full, or if the sale is not completed by reason of any default on the part of the successful bidder, or for reasons beyond the control of the authorized officer shall at his discretion be entitled to forfeit all the monies of purchase consideration paid to then by the successful bidder and put up the secured assets in question for resale or disposal to the second highest bidder for best value. Further, all costs and charges shall be recovered, borne by the successful bidder, which shall also be counted.
What is this? What is this instrument?
This is the terms on which, my lord, the auction was conducted. It's the bid document. It starts at page 30, my lord, the bid document.
What 14 says?
14, Lord, says it's two parts. One is how the sale must be completed. That is the first part. The second part is if they fail, what is the consequence? There can be resale or disposal to the second highest bidder for the best value.
For resale or disposal?
Yes, resale is the first part according to me.
Ah.
But disposal is to the second highest bidder for the best value. It can't be resale, not to the second highest bidder. So the options that the secure creditor has.
No, for its best value.
For the best value. Second high. Yes, no, my lord, what I'm humbly submitting is there is a, without going into what has happened in our scenario, there could be a situation where the first bidder comes, he doesn't deposit the 25%. And in this case, my lord, I think how many, about 8 to 10 times they've made efforts to sell this property, never worked, and it's failed. So if the first or the highest bidder fails to deposit, let us say the 25%, the EMD is forfeited. And thereafter, I have two options at that point in time.
This negotiation with you happened when?
Not after the disposal of all these proceedings.
Of course, it must
Yes.
be like that.
In my additional statement of objections.
Negotiation with you happened when?
Yes.
What was your bid?
My bid, my lord, was about 8.5 crores.
Subsequently, after negotiation, to what you have enhanced it to?
We initially went to 12 the same value as offered by the first bidder, 12.88 crores. And then, Lord, after checking the boundaries of the property and the fact that a portion of the property had been acquired by the KIADB,
So this happened when? On which date?
April 20, 2000.
For a short, just give me the foundational facts.
Yes.
Auction took place on?
Or auction took place
12/1/2016.
Yes. 12/1/2016.
And the highest bid was 12.88.
12.88 crores. That was then challenged by them.
That was challenged.
That was challenged by them, my lord. And on 18/5/2016, the application was dismissed.
By DRT.
By the DRT.
That was challenged under which section?
That was challenged before the DRAT.
DRT dismissed on,
18/5/2016.
why they challenged having staked for the
Sale
highest?
notice was, original sale notice was challenged before the DRT.
That was before sale. No,
Yes, yes.
pursuant to that one only.
No, before sale one. They have issued a sale notice, my lord.
Ah,
That is on 5/12/2015, fixing the auction on 12/1/2016. I have challenged the sale notice before the DRT. DRT passes a conditional order. I comply with the conditional order.
saying,
I deposited 1 crore. DRT said, you go ahead with the auction not to confirm the sale.
okay.
That I have complied with. That interim order was in force even after the disposal of that essay.
Even after disposal, it was
Yes,
enforced.
it was extended for 1 month. I have moved a memo so that I requested the tribunal to give me some time because DRT was not functional that time. So I sought for a time not to precipitate the
So,
execution of the order.
DRT dismissed your challenge.
DRT dismissed my essay
Yes, sir.
against which I preferred an appeal before the DRT.
This was on dismissal on
18/5/2016. In essay number 4 of 2016. Subsequently, this order was challenged by me before the DRT.
28/7/2017.
Yes.
dismissed on.
This was subsequently, what has
that
happened
is
is
AIR ಆಗತ್ತೆ ಅನ್ನೋದು?
AIR 105. There, the DRT passed the conditional order.
2016. Huh.
17, my lord. That was 17.
28/7/2017.
No, AIR 105 of 2016.
Yes, ma'am.
Here 105 of 2017.
17.
2017.
On 30/8/2017,
Huh.
I was permitted to withdraw the appeal because in DRT, I obtained an interim stay, conditional stay in DRT when I preferred an appeal. Before I comply with the interim order of the DRT, in the original application proceeding, the tribunal below has discharged me from the entire liability. So therefore, tribunal permitted me to withdraw that appeal because it has become infructuous. There is no, that is on 31/7/2017. I mean 38/2017. I was permitted to annexure E at page 85 to 86.
As having become infructuous.
Yes. Because I was discharged from the entire liability in OA proceedings.
On what ground?
I was discharged. The guarantors were discharged
On the ground?
on loan terms and conditions have not been
Variation
complied.
of terms.
Variation of contract. This AIR 105 of 2017, TR80, has passed an order.
OA number?
OA number 109 of 2017.
By the bank was
Bank has filed that OA
as against you.
against me and other borrowers.
TA.
Thereafter, it was converted as transfer application.
All right, dismissed on.
This OA number 109, 31/7/2017.
31/7.
31/7/2017. The borrowers, the petitioners were discharged from the liability.
Okay.
Therefore, I could not comply with the DRAT's order. DRAT permitted me to withdraw that appeal as become infructuous.
Okay.
Thereafter, the secured creditor preferred an appeal
Not thereafter.
against my discharge.
Not thereafter. It was, appeal
After.
was pending and that was recorded also by the
when?
DRAT. Saying appeal is pending, but it's up to you. You withdraw it, you withdraw it.
Yeah, one second. TA 109, I was discharged, my lord. Against that order, the secured creditor assignee.
TA or OA?
Originally, it was OA
Then it
because
was
it
TA.
transferred from one tribunal to another tribunal because of jurisdiction.
Okay.
Secured creditor assignee preferred an appeal against my discharge before the DRAT. DRAT reversed that order. Against that order, I preferred a writ petition. There was a stay. Finally, this
DRT order is dated
14/3/2018, my lord. Annexure F. Against this order, I have preferred an appeal before this honorable court. There was a writ petition. That is writ petition number 20318 of 2018.
What happened to that?
That writ petition was dismissed, saying that nevertheless you are discharged from the guarantee because of your mortgage, your liability survives. Mortgage survives irrespective of the fact that your guarantee has been discharged. After this, the secured creditor assignee has sold the property to the present auction purchase.
WP another?
My lord,
Your WP?
WP number 20318, Annexure G, which I have filed. 2018. Writ petition was dismissed on 17/5/2018. Dismissed on 25/2/2020.
Huh?
After this, sale certificate was issued.
By 2018.
That's a petition, Lord.
Writ petition.
Date of filing.
Think
Dispose.
it is.
No, it was dismissed on 25/2/2020. I'm sorry, ma'am.
Filed in 2018, dismissed in 20.
25/2/2020.
Yes.
After this dismissal, on 17/8/2020, the assignee secured creditor issued a sale certificate in favor of this respondent number 1 and 2 here and now,
1 and 2.
after 4.5 years.
Ibru bidders now.
Yes,
Same bid was by.
that's the second highest bidder.
Because of this, there was a 4.5 years gap between the date of auction and the date of issuance of sale certificate. This sale certificate,
The negotiation took place when?
2017,
2017.
17 and 18.
But auction took place on 12/1/2016.
Yes.
The negotiation happened after?
After, my lord, the successful bidder was permitted to withdraw from the bid. That was done by an order of this honorable court, which
When he withdrew his
30/3/2017,
30th of March 2017.
30th March 2017, wide writ petition number 35192 of 2016. Annexure C, my lord.
bid on
30/3/2017. 30th March 2017. Then they have called this next bidder and they have proceeded. In fact, my lord,
negotiation took place on which date?
My lord, 24/4/2017, on 20th April, sorry, 20th of April 2017.
April 17.
Yes.
in fact, my lord, when I preferred a writ petition against the DRATs reversing the DRT order in the OA proceeding in writ petition number 20318, division bench of this court has granted me an interim stay, which is at Annexure H. Honor, may kindly see that.
Saying
Page,
page ಅದಕ್ಕೆ ಏನು ಅಂತ ಹೇಳಿ. ಅದರಲ್ಲಿ
in that proceeding, while interim order was passed, they have given an undertaking to the court that they will not precipitate the matter.
Is it true?
Yes, my lord. I have filed that Annexure G, my lord.
But they precipitated
Not sell the
during the operation of stay,
They didn't sell the property during the.
Lord, at
operation
page
of the-
95, my lord.
95.
Yes, my lord. That is an interim order passed by this.
The direction was there should be no sale of the property in question
I'll
till
read-
the next date of hearing. Be clear on what the order is. Page 96.
96, my lord. May I read, my lord?
Check it. No sale of property in
property.
question till next date of hearing.
There's no sale.
This, ultimately, this writ petition was dismissed in 2020.
And then the sale.
After this, they have confirmed the sale to the next bidder.
But this order is dated
This is dated, my lord.
17/5/2018.
but negotiation took place on 20 April 2017.
17.
The meanwhile,
In the meanwhile.
the sale, then whether
Then
this
they have
order was.
issued the sale certificate on 17/8/2020, which is at Annexure J, my lord. Page
At that time, there was no interim order.
No, because the writ petition was dismissed.
After the
Dismissed.
dismissal of the writ petition, immediately within a week, they have done it.
Correct.
In fact, I have approached the secured creditor. I have sought for a time to settle the matter. They have called the second bidder. I have given a representation. They have not responded.
On which date you gave the representation?
That is not.
That is on 31st March or so, my lord, 2020.
No, no,
Huh?
only-
March 2020, my lord.
March 2020.
Because the final order was passed in 25/2/2020. 31st March, we had been to secured creditor's office at Bombay. We have given a representation.
Not on record.
That they have not responded. Then they have
Where
called.
is that? ಎಲ್ಲರ ಬೇಕಲ್ಲ ಅವ್ರ ಕಡೆ.
That letter is not part of this report.
Then don't argue.
I'm sorry, ma'am.
Don't argue.
I'm sorry.
What is there you can argue.
Yes, ma'am. Then after this, my lord, the sale certificate was issued. That is on 17/8/2020. Then this sale certificate, I have challenged it before the DRT, saying that auctioning to the second auction purchaser is
Right.
contrary to the provisions of law.
You filed essay
SA 146 of 2020 in DRT.
dismissed on
It was dismissed on 28/4/2023. I'm sorry, my lord, it was allowed. It was DRT. DRT has allowed the SA 146. And sale certificate was set aside.
saying allowed on
28/4/2023. Saying that calling the second bidder, which is contrary to the provisions of the act.
therefore go
They
for
have
fresh
relied on
action.
Taylor versus Taylor and they have
fresh action.
fresh auction to be conducted. This order, the secured creditor assignee did not prefer any appeal.
This is set aside by
By the DRA.
AAR. AAR?
No,
That
no.
is
RA.
say 37 of 23, my lord.
RA. Regular.
RA.
RA in SA, which was filed by them, against which the present writ petition is filed.
RA number?
37 of 2023. Dismissed on, allowed on 18/7/2024. Reversing the order of DRT, setting aside the sale certificate. There is no stay obtained by the respondent from DRT. In the meanwhile, the sale certificate was cancelled based on the DRT's order.
You offered 21 crore when?
This was on
July.
3/7/2024, madam.
3/7/24
24.
after dismissal of your allowing of RA.
Yes, ma'am. Their appeal.
SA, allowing of SA.
RANS.
RA.
RASA.
Annexure M 195.
This is an annexure M, madam.
Next means you deposited 15 crores.
15 crores.
Same day.
Within a week's time, that letter is part of this.
Your letter is dated?
1 second.
2nd March 24.
No, 3/7/24. That's what they produced.
3/7.
Lords, the proposal is dated 2nd March 24.
When that was given?
It was
Lords, 2nd March 24 it was given, and page 195 minutes it was approved on 3rd July 24. Page 195.
Annexure M.
Second paragraph minutes. Letter dated 2nd March 24.
ಏನಂತ ಹೇಳಿದ್ರು ಅವರು? Agreeable to accept your proposal.
Agreeable to accept 21 crores.
21.
The para 3.
RCL is agreeable to accept your proposal for release of RCL's charge.
So pursuant to this, you made payment of 15 crore. When?
15 crores. Balance 6 crore is pending.
When you made 15 crore?
This was
Within 30 days, 197 minutes. It's paid within
the
that.
first installment.
They were supposed to pay 16 plus 5, 21 crores.
Which is at page 197, my lord.
197 from.
Totally 21 crore you were supposed to pay.
Yes.
On or before 30 days, 16 you had to pay, but you paid only 15.
15 year.
One is lacking.
6 crores is still pending.
6 means first conditional is 1 crore pending ittu.
Or I don't think they've. The
But
total
first
amount
condition
they
was
have paid is
fulfilled.
only 15 totally. Including the upfront payment, it appears they've only paid 15 crores till now.
15 crores they have paid.
Lords, upfront payment of 5 crores was paid. In the second installment, 9 crores is paid. 10 crores is paid, 6 is pending.
Only 10 crore paid, not 15 crore.
16. We were required to pay 16. 10 is paid, 6 is pending.
I signed 15 crore is paid, man.
It is paid. 15 crore is paid. Ask your
Yes.
client is here, na? Yes, sir. March. Okay. The day they received this settlement letter, they handed over other.
At the time of application, he has paid 5 crores.
5 crore.
The
plus
day he
10
has
crore.
received this letter, he has paid another 10.
10 crores.
Correct.
That's correct.
Then the entire settlement goes because the balance has not been paid.
Oh, that's not for the auction. But
Interest rate
All
is
right.
you only.
When did we
The
get
balance 6 crores, I would have paid it because when this writ petition was filed, there was an interim order which is continuing. They said if the interim order is not granted, they will go and pay the balance 6 crores. I'll be without remedy here. Therefore, this court has granted me an interim order. So because of that, I could not pay that 6 crores. Otherwise, I would have paid it.
Interim order did not prevent you from making
No,
payment.
status quo to be maintained. That is what it's said.
ಇದ್ರಾಗೆಲ್ಲ status quo.
Because he was very specific. My learned senior counsel was very specific. Let the status quo be granted.
Status quo is with regard to possession of property. ಇಂಥದಕ್ಕೆ ಕೊಡ್ತಾರಪ್ಪ construction, possession. ಇಂಥದಕ್ಕೆಲ್ಲ status quo unheard of. Anyway, judges have given that. We can't comment on our brother judges.
Lords, the reason why it was given was that the other side submitted that if 6 crore is paid, nothing remains and they will be left remediless.
Where's the interim order in this?
So, my lords, this was what was sought to be addressed by your lordship's intervention in the matter, my lords, where it said that, all right, let the state of affairs continue because they are having a grievance that if 6 crore is paid, they'll be left without a remedy. And the writ petition may not survive for consideration. That probably prevailed in the mind of the court, my lords, in interfering with the kind of order.
Where is your 5 more crore now?
Lords, your lordship, lords, I can immediately, my lords, because of this. Otherwise, if your lordship fixes a time within which I should give it, even otherwise, my lords, if your lordship were to fix a date, my lords, for payment of this money, I'll come with the demand draft and pay it.
The interim order granted by your lordship is petitioners and respondent number 1 to 3 shall maintain status quo with regard to title and possession of the property in question till the next date of hearing. That's all. Nothing else.
Correct ಇದೆ ಅದು. ಆರ್ಡರ್ ಇವ್ರು ಹೇಳಿದ್ದೇನೋ ಬೇರೆ ನಮ್ನಿ ಇದೆ ಅಷ್ಟೇ.
But that was a statement made, my lords, when the
No,
interim order
no
was
such
granted.
statement that you don't deposit 6 crores, don't do anything, don't comply with that. Nothing of that kind was said.
ಟೈಟಲ್ ಪೊಸಿಷನ್ ಬಗ್ಗೆ ಮಾತ್ರ ಇದು ಹೇಳಿದ. ನೀವು ಅಟ್ ಲೀಸ್ಟ್ ಬೋನಫೈಡೆ ತೋರಿಸ್ಲಿಕ್ಕೆ ಆ 6 crore ಇಲ್ಲಿ ತಂದಿದ್ರೆ we could have considered that also.
But your lords will have this matter even next week, my lords. We will get the demand draft and then show our bona fides and then go on with the matter. I will not say that I fully bow down to what your lordships is expressing, my lords.
No, next
Absolutely.
week, Ravi Shankar, you know this court. No question.
That's the reason why I said, my lords.
Installment in this court.
No,
Oh,
certainly we are not
same.
paying any installment.
So this is the position.
This is the position. Now, there was no interim order from this court preventing them from paying the money. They could have always paid it without prejudice to whatever is the outcome in these proceedings. Because if ultimately the writ petition is decided in my favor, upholding the order of the DRAT, then the consequence will be to return the money that has been taken from them. Because the money has been taken to release them from the mortgage as well as the
You
personal.
have taken the money back.
No, I am for the successful bidder.
You
My lords,
have taken
it
money.
is between me
bidder,
and the bank. My lords, it's
Successful
me.
bidder.
I'm the
Yes,
successful
yes.
bidder.
No, whatever amount you had deposited, did you take it back or
They
still
returned it, my lord. They returned it by a demand draft.
when they
We
returned it,
received it without prejudice.
what was the amount you had deposited?
11.8 crores.
11.3 crore. you had
11.3
deposited.
crores, which they sent it back to us, which we received not without prejudice. And said,
With interest. With interest it
With,
is given.
my lords, it is deposited back with interest, my lords.
yes, yes.
13.47 crores.
They sent it, my lord, with interest, which according to us, the interest calculation is not correct. But in any event, whatever interest they sent, which we said we can't accept, but we encashed it under protest. Page 49 of my statement of objections.
They have received 14 crores, 47 lakhs, 19,570.
As against 11.3 crores.
7% interest awarded by the tribunal. The differential amount of 3 crores, 17 lakhs, 19,570 has been received by them by way of interest. My lord may kindly see 193 DRAT's order. There is a direction to them also at page 194, my lord.
Saying
The appellant shall pay back the money that they have received from the respondent number 4 institution through letter dated 23/11/2023 within 15 days from the date of this order, which they have not done it.
This they have
On
not done.
receiving the said amount from the
DRAT.
appellants, respondent number 4 institution shall revoke the sale certificate dated 17/8/2020 within 30 days thereafter. Both the parties shall bear the own cost, all pending IAs if any stands closed. Appeal is accordingly closed. So DRAT's order they have not applied.
DRAT order, did you make the payment?
No, we've not redeposited the money because we challenged it, because they challenged it before your lordships. That's the position.
They filed writ petition on when?
They filed the writ petition, Lord, on
This was filed on 7th August 2024, my lord.
7th August.
Sorry, my lord. It was filed on 26th July 2024.
Yes.
The DRAT order is?
DRAT order is
18
dated
July. 18 July.
18/7/2024. 18/7/2024. And the writ petition was filed immediately on 26/7/2024. And
There was no stay order, my lords, that they should not deposit the similar to what your lordships observed for us.
You filed WP when?
WP was filed on 26th July 2024.
26/7. A notice came to you when?
We were on KVAT.
On KVAT.
You were in KBA.
We were on-
The first day of admission. both
Prohibition for your making the deposit.
There's no prohibition. In terms of the interim order, there's no prohibition. But the fact remained, my lord, was we've been constantly out of pocket.
Because they have not deposited, they have insisted on a status quo.
Again, we are asking you whether any negotiation is possible, then that amount not possible.
I can't, I've not
Heard
spoken to
result.
them, my lord.
Heard result.
Can I now make one more point? There's a couple of other points.
That's before my learned senior friend, just one judgment, my lords, I'll draw your lordships' attention to.
Yes.
Because my lords, only one judgment, my lords.
Yes.
A division bench of the Orissa High Court dealt with exactly a same situation. Lords, in the list of citation, it's the last judgment, lords, which your lordships will find
No, in my
What's
memo
the
of
first
citation,
judgment?
my memo of
First
citation. First
memo of
judgment, Mr.
citation,
Ravi.
the first judgment itself, my lords.
But.
Again, page.
Lords, at running page 3.
Very good. Very good.
Lords, at running page 3, the second unnumbered paragraph extracts rule 9.3. After 9.2, rule 9.3. On every sale of immovable property, the purchaser
Correct.
shall immediately.
Yes, correct.
Yes. Purchaser shall immediately pay a deposit of 25% of the amount of sale price to the authorized officer conducting the sale. And in default of such deposit, the property shall forthwith be sold again.
Sold again. What
Again.
is meant by sold again anta?
Now, kindly have a look at para
8 by 8.
Para 14 and 15. A bare reading of the above rule would go to show that the prescription in sub-rule 2 is that on every sale of immovable property, the purchaser is required to deposit 25% of the amount of the sale price with the authorized officer is immediately. If it further prescribes that in default of such deposit, property shall be forthwith sold again. Emphasis applied. In our view, therefore, the phrase sold again cannot mean that on the failure of the highest bidder depositing 25% of the sale price, the property should be sold to the second highest bidder. Rather, it is a mandate under sub-rule 2 quoted above that the sale shall be confirmed in favor of the purchaser who offered the highest sale price in his bid or the tenderer or quotation or offer. Hence, if a harmonious interpretation of sub-rule 2 and sub-rule 3 of rule 9 of the rules is made, inevitable conclusion would be that if the highest bidder fails to deposit 25% of the sale price immediately, entire process of sale by public auction prescribed under the proviso to sub-rule 6 of rule 8 will have to be followed forthwith. That is the even the Supreme Court confirms this order, though in a different terms, where the mandate in terms of lords, may kindly have a look at internal page 3 of this very same judgment, so that I will clause 595. This came up for interpretation in Shanmugavelu's case.
Page
9.3 and 9.5. In same internal page 3, that is rule 9.5. In default of payment within a period mentioned in sub-rule 4, deposit shall be forfeited and the property shall be resold. And the defaulting purchaser shall forfeit all claim to the property or to any part of the sum for which it may be subsequently sold. So this phrase conspicuously finds place in two places. In default of 25% to be sold again, even if the entire amount is not paid, again to be sold again. This is held, Milords, in Shanmugavelu's case is a mandatory provision, including Rule 9.3.
But whatever amount did you deposit any amount?
Milords, earlier we had deposited 1 crore rupees. Milords, what happened? Your Lordships intervened. There is one more issue to this, Milords. When we challenged the auction proceedings before this Honorable Court granted an interim order saying that the sale shall not be confirmed subject to depositing of 1 crore. 1 crore was deposited. The sale was confirmed during the subsistence of that interim order. No doubt, subsequently, the writ petition. But in Jihal Tanti's case, the Supreme Court says that once the interim order was operating, anything which is done in violation thereof, will be non-est and void ab initio. The other series of judgments have.
I have to still make my
referring to Supreme Court affirmed. Supreme Court affirmed this, na? You said which
Shanmugavelu's case, Milords. Shanmugavelu's, Milords, it's not a part of this compilation. Yes. 2024, volume 6, SCC, page 641.
This Orissa went in appeal.
Milords, this Orissa became final. Milords, in another context, Milords, this came up for consideration is what I'm submitting. Just the mandate, Milords, as to how it should be done. The reason why I am submitting this is the maximum period under sub-rule 5 of rule 9 is 90 days. 90 days under no circumstance can be extended. Here it was accepted after 4.5 years. Page number, paragraph numbers. Notes, can I just request your lordships may kindly take page 643 minutes of this, which extracts
Running page.
paragraph number 32 and 33.
Running page.
Notes, page 643, running page 643. In the head note minutes, I'll just point it out and take your lordships to the relevant portion.
Here it is 33 minutes.
33.
Para 60 and onwards deals with the mandate, but in this.
9.3 is not considered in this judgment.
No, it's 9.5 was considered in this judgment. The reason why 9.5 I am referring to is, even if the sale is to be confirmed in favor of the second bidder, even then it is only 90 days, not beyond. The sale cannot be precipitated for years to come. The whole object is twofold.
At the earliest it should be
speedy recovery, and lapse of time, there will be escalation in the prices. Even the Supreme Court said that there is a long lapse of time between the sale, first sale and the second sale. There is a requirement of a fresh valuation. So 90 days is a mandate. Under no circumstances, period of 90 days can be extended. Similar to the interpretation given, to the provisions of the Commercial Courts Act, so far as filing of written statement is concerned, Section 34 of the Arbitration and Conciliation Act. Similar is the language employed in this case.
Proceedings. No.
And one more judgment, Sardar Singh. There we go. But Selir LLP, there is one very interesting judgment, belongs of the Supreme Court. I think my learned friend is having the judgment, belongs. Selir LLP, 2024 SEC Online SC 3727. A very interesting judgment, belongs.
Selir
SELIR, Selir LLP.
ನಿಮ್ಮಲ್ಲಿ ಇದೆ ಏನದು ಏನು ಹೇಳಿ?
The principle is, wherever a sale is challenged under the Code of Civil Procedure, requirement is we are required to establish that there is a miscarriage of justice under Order 21, Rule 90. This was distinguished by the Supreme Court where the sales which takes place under the statute, like a Revenue Act or the Companies Act, or for that matter the Surface Act, where the yardstick for the purpose of assessment to set aside a sale is to find out whether a mandatory provisions is complied or not complied. If it is found it is not complied, it need not delve further whether there is any miscarriage of justice or not. It should stop there. If your lordships were to see the scope of inquiry under Section 17, Section 17 again mandates under Section 17.4 and 17.7 that the tribunal will make an assessment whether the provisions of the Act and the rules is complied with to take the measures under 13.4 or not. That is all the scope. That is what is spelled out by the Honorable Supreme Court in Selir. It says that in revenue sales, it stops at the making of an assessment whether the mandatory provisions is complied or not complied. If it is not complied, it's over. That is the end of the story. These are the two judgments. I'm grateful.
Yeah.
Yes.
That's fun. There are two things, my lord, which I want to make in terms of law. One, of course, I pointed out to lordships on Rule 8 and Rule 9. There are two parts. The second, lord, is you don't get two bites at the cherry.
Huh?
You don't get two bites at the cherry. There's only one bite at the cherry. And you exercise that first bite when you challenge the sale. The entire sale proceedings was challenged first. You failed before the DRT. You went to the DRAT. You were asked to deposit. You did not deposit. By which time your liability was held to not exist because you were discharged as a guarantor. Then, Lord, you took the risk of saying, I'll withdraw the appeal, which I filed before the DRAT.
No, he withdrew because OA was decided in his favor.
Absolutely. But I had filed an appeal and the appeal was pending at that point in time. Was pending before the DRAT for consideration. Therefore, you withdrew it without any liberty to re-agitate the issue or otherwise. And thereafter, the DRAT found that the order of the DRT was wrong. DRAT set aside that order.
Correct.
Confirming his liability, which was there. At that point in time, he had the option of reviving that challenge, which he did not do. He left it as it is. A writ petition instead was filed challenging that order where he was discharged. This honorable court elaborately examined the issue and finally found that you are not discharged, either as a guarantor or as a mortgagor of the property, and said you can proceed with the sale. Now, in all of this, there was an interim order in some way or the other protecting them. Therefore, this argument, this 90 days, you must do it, really has no value anymore, because you have prevented any sale from happening by ensuring that there is an interim order from one court to the other. And our lordships know, when there is an interim order, there is no question of then saying that the 90 days is sacrosanct.
Time will not.
Time will not run because the 90 days is not ended. Therefore, my learned friend's argument that 90 days is like Commercial Courts Act is saying that if your lordship stay a proceeding in the court, still the 90 days will end or 120 days will end and then you can't file a written stay. That may not be entirely correct. Why I'm respectfully pointing this out is, if your lordship sees the judgment of the Orissa High Court on which so much of reliance is placed on, the petition was filed by the second highest bidder. The prayer was, confirm the sale in my favor because I'm the second highest bidder. That was not an option of the secure creditor, not the option of the second highest bidder. Which is why if your lordship sees the next paragraph, which my learned friend did not show your lordship.
There they said we don't agree with the submission of next paragraph.
Next paragraph they say,
that.
Yes, exactly. It says the second highest bidder cannot come and say, now confirm it in my favor because the first highest bidder has defaulted. Therefore, it is not, if I may say so with great respect to my learned friend, a case pari materia with this. Secondly, my lord, if the terms and conditions of the bid document provide a mechanism by which the secure creditor can deal with a particular issue in a particular manner, and he has done so. He has made an offer to us. We have responded. And thereafter, after determining the exact area, we have offered a particular price which has been accepted. And before it could be registered, another interim order by the DRT, by the High Court, stopped the entire process there. After the order was passed, dismissing, my lord, their writ petition, challenging the order of the DRAT, the final sales certificate was issued. Now, it can't be said that you did it for the first time in 2020. The entire case was, you did it for the first time in 2020.
But anyway, within the period prescribed by DRAT, you did not deposit the money at all, though there was no stay.
No, yes, I have not. Yeah. But that will not, in my humble submission, because there is a challenge pending. Insofar as that is concerned. No, we are also willing to deposit it straight away.
Yeah, are you agreeable to deposit the amount which they have deposited now?
Which, my lord?
21 crores, my lord.
They not deposited 21 crores first, my lord.
No, 16 they have already deposited.
No, this
15,
is
10 plus 5. And another, within 1 week, they are going to deposit 21. If you are agreeable to 21, because public money is involved. Public money is involved.
That I can find out, my lord. I don't know. I mean, I don't have an answer to that question today, my lord, because that was not put to me earlier. I can find out. But the point really, my lord, is this. The validity of the auction.
Otherwise, around 9 crore order, they will the bank will lose.
Yes.
Bank, my lord, has...
There is some fault on your side also, in the sense whatever the period was given to you by the DRAT.
Yes.
Within that, you have not deposited, and stay was not with regard to that at all.
Not deposit. The order was that I must deposit and they must execute a sales certificate or cancel the earlier sales certificate.
Correct.
Which could not be done because of the order saying you cannot alter the title of the property.
Now, for making payment, where was the contradiction?
No, my lord. In my humble submission, both run together. The payment, if your lordship sees the order, I should pay back the money. On receiving the amount, I should revoke the sales certificate.
Correct. On receiving.
Now, of course, when my friend is here, I can at least ask him not to say.
He is agreeing with you, perhaps.
Normally, he doesn't, but today maybe. But the consequence, is there can't be a transfer of the property. Now, therefore, both have to be given effect at the same time. I can, of course, not deposit it immediately. There's no difficulty. Deposit it, if they execute a sales certificate, I'll take the sales certificate.
No, the bank's money is a public money.
No. But then that could happen in a variety of scenarios. A sale is done. Afterwards, after the sale is concluded.
Therefore, we'll compensate you.
May I just...
See, bank, nearly 9 crore will go. Many have taken away the money of this country to other countries is another thing. But here is a case where the highest, the person is coming now.
The borrower
is saying, we will give you 21 crore. 15 crore he has already paid.
That will
not
I want to put it slightly differently.
He is a guarantor, not borrower.
Guarantor makes no difference. Guarantor is the most pampered borrower.
Lords,
Put it
under the
otherwise, Lord.
definition,
May I just say
under the
this?
definition of borrower under the SARFAESI Act,
Ah.
Lords, very conspicuously, because this issue would have cropped up, the Parliament in its wisdoms thought appropriate to include a guarantor in the definition of borrower
That's what.
Correct.
under the scheme of the SARFAESI Act.
Therefore, you
So
can't
borrower
can't
includes
chant-
a guarantor.
Therefore, you can't chant
weak
mantra
media
of
in saying that.
guarantor.
But I want to put a slightly different point. Lord.
Because they have even watered down that principle that we cannot
Yes.
Suppose, my lord,
property.
a sale goes through and a sale certificate is issued. After the sale certificate is issued, the borrower comes and says, I'll pay you a higher amount of money. The sale can't be cancelled.
No, that's not it.
No, I'm saying
Because
no,
there is already
ultimately.
conclusion.
No,
there is a
it is also,
concluded
I also had a
transaction.
sale certificate in this case. And a sale certificate registered, my lord, a sale certificate registered was revoked because of the order of the DRT. And then, my lord, after it was revoked, they then accept a proposal from them for the money and then say, we will proceed. It also is a scenario where the bank takes varying positions at different points in time.
The primordial object of 2002 Act is to secure the money back. That is the primordial object. Consistent with that, rest of the things should be done.
My lord,
Yes.
I would put it slightly differently, my lord. I would say if the primordial object of recovering money is now hedged by legal considerations as well as a mechanism which is provided under the statute, then whatever the consequence of it, my lord, will automatically follow. Whether it results in higher or lower, it could be, my lord, that if you delay it long enough, you may get a higher price. But a bank may say, I want to sell it today and recover the best possible price that I can find. And I get this price, I'm happy with it. It was happy in 2017 when I accepted that money. But if they had not challenged it, or they had kept quiet, or this court had not granted an interim order, a sale certificate would possibly have been executed on that day. But it wasn't, not because of an order of this court. And therefore, in my respectful submission, the scenario can't change because they then by 2020 have been able to garner some money to pay my lord and then come and say, I will now upset a sale which has already occurred.
With my lord's permission, would like to clarify with regard to the
Just-
Rule 85 submissions made by Vicina Council.
Lords, Ashok, 1 minute. Lords, I'll just clarify what my learned senior friend. Lords, whenever we are speaking about the exercise of statutory power, any exercise of power should be sourced out of the statute. Statute should permit. Lords, this remedy which is provided under 2002 Act is a very special remedy, specifically conferring powers on an officer who is called as an authorized officer, which could not have been exercised otherwise than the provisions of the Act. Every action of his should stem from what is specifically, explicitly, or even impliedly provided for under the scheme of the Act. Now, the question is, if the authorized officer wants to call for a second bidder, where is the source of power? That he has to trace it to any provision, my lords, whether explicitly or by any
8.8.
interpretation.
8.8 he is quoting.
Lords, that's the reason why I said 9.3. If your lords were to see
Doesn't
Rule
override.
9, Rule 8.6,
That doesn't
and Rule
override.
9. Lords, now Rule 8.6 provides very specifically the manner in which the auction is required to be designed, valuation, then what is the due, how the notice is to be served. Then Rule 9.1 comes. If your lords were to see Rule 9.2, Lords, it makes, lords, because 9.2 is what actually captures this. Of course, Orissa High Court doesn't very explicitly deal with 9.2, but lords may kindly have a look at 9.2. Because there is an exclusion.
ಬ್ಯಾಂಕ್ ನವರು ಹೇಳೋದು ನಿಮ್ದು ಈ ಆರ್ಗ್ಯುಮೆಂಟ್ ತಗೊಂಡು ನಾವೇನ್ ಮಾಡಿ ನಮ್ ದುಡ್ಡು ವಾಪಸ್ ಬಂದ್ರೆ ಆಯ್ತು ಅಂತ ಅವ್ರು ಸುಮ್ಮನೆ
Now the bank is very happy because they are getting more money. 9.2, your lords may kindly see, because there is an express bar. May I read it, Minots? The sale shall be confirmed in favor of the purchaser who has offered the highest sale price in his bid or tender or quotation to offer to the authorized officer, subject to the confirmation by the secured creditor. Lords, the second bidder is excluded explicitly. Lords, number one. Second thing, what happens is 12.88 crores is the first bid, highest bid. Second bid is called for 11.3 crores.
That explanation is there in the additional statement which we filed as to
No,
how it has been done.
no, Milords, they
No,
may
that-
say, Milords,
make
every
statement-
property, if your lordships were to see the rules, Milords, it is brought to sale on as is basis. No sale is permitted under the SURFACE Act with a lever to operate to meddle with the consideration. Once the bid is made, it is over. It is on as is basis. Lordships may kindly see Rule 8.
Come to 8.8.
My lord, that is
Lordships,
applicable
Rule
only
8.8.
it is a private treaty.
Private, yes.
This is a public auction.
Private treaty,
Rule,
Milords.
rule 885D, my lord.
Yes.
Rule 8,
Milords, what are the modes
Rule
of conducting?
8D. Modes of auction is prescribed by the Act. That Rule 8 is refers to the auction by way of private treaty, not by an auction by way of public auction.
It's okay. There.
Whereas this auction,
I just complete this.
they have, even for that also, they have to issue a notice by posting, pasting and publication, and they have to
Milords, it
do
is
the
again
valuation.
resold. Milords,
Every rule,
kindly
every
have a
time
look
is mandatory, my lord.
Straightway they cannot deal
They
with
can
the
do.
second.
What the Leonard Senior Council was telling is, since the first bidder failed, we had a negotiation in between when the matter was pending in the court, and we have reached a conclusion. We have sold it to the second bidder. That is not contemplated. One, this is the difference I want to point out. Second thing, as far as the Orissa Division Bench judgment is concerned, the bank has re-auctioned the property again. The money has been returned. Even in this case also, had it been a re-auction, I have no case before Your Honor. That's where the secured creditor went wrong.
Please, Milords.
Reserve.
Grateful, Milords. Grateful, Milords.
Do you want to, see, we are asking you, you said you will be able to give rupees 50 lakhs to the.
That we have agreed, my lord. Yesterday itself we have agreed.
Milords, yesterday a
It was the
statement is
proposal
made,
in this
Milords.
one. Now lot of arguments have taken place. After all, where, how we are going to decide, we do not know.
One clarification with my lord's permission. What they have paid is 11.3. What they have received is 14.47.
Yes.
That is at 7% interest.
7% interest which DRT has
Which
awarded.
businessman will accept 7%?
Right, my lord. I agree. I didn't say no to what your lordships has directed me yesterday.
No, we did not direct. We were only discussing.
Right. And they have already received more than 2 crores by way of interest. Still, my lord wants me to pay. I'm ready to pay that 50 lakhs. I want a piece from this matter.
But 50 lakhs will not give you peace to him.
My lord, they have earned the interest.
No.
My lord, may kindly see when the payment of 75% was paid. It was paid only in 2020.
All right. Therefore, if you come out with something, that also will be one of the factors for us to consider.
Milords, as your lordship suggested, Milords,
Yes.
because Milords, now,
in
so
that
far
they
as the
will
bank
get
is concerned,
367 if-
Milords, so far as the bank is concerned, bank is getting benefited for the fact it's a public money. We are offering, Milords, 10 crores more than what was actually offered by them, 11.3.
All this, it is not that some arms being given to the banker.
No, Milords, I'm only
You were
equitable
liable to
circumstances.
pay. That
Milords,
is only, you are only.
Milords, I'm only submitting, Milords, that your lordship suggested 50, we put it across, Milords, and we have agreed to pay this money because yesterday when this was put across, we have agreed to honor this and, Milords, we will abide by what your lordships have directed, is what I can make a statement, Milords. This is what we put it across and what fell from the court, we have got it agreed,
It's a
Milords.
bona fide auction purchaser.
Do you want to improve that proposal is our question.
I bow down to your lordship's direction.
Where is the direction? Direction is improve.
Milords, that again, Milords, we may have to.
Otherwise,
we may
see,
have
this
to-
is a very tough case. Can be decided this side, that side. It all ultimately law is what we say.
Had it been a bona fide auction purchaser who is coming before this court and saying,
All
I
these
understand.
problems arose because of your client.
I'll ask the client.
Had he if he were to be a scrupulous borrower, he would have straightway given the money. Ask him whether he is agreeable or not.
He is ready to pay another 25 lakhs, my lord.
Milords, your lordships may accept that because it's more than substantial, Milords. What they have already received, Milords, I can understand, Milords, if this borrower, this auction purchaser came into play because of the second auction, then I was absolutely in your lordship's hands. Milords, here it is because of an internal understanding between the bank and the second highest bidder, Milords. This scenario is being faced by me. Milords, if a situation had arisen that the property had gone for re-auction, then I was not
one more aspect. Adana 1 crore ಅನ್ಕೊಂಡು ಒಂದು ಮೆಮೊ ಹಾಕಿ, we do not know. Still we may not agree with that. Because suppose I have to process this. ಈ ಕೊಟ್ಟಂತ material sufficient ಆಗಲ್ಲ. ಹೀಗೆ ಅಂತ. If you agree to give 1 crore, file a memo. It will be one of the factors in deciding the matter. It's not that if you agree to 1 crore, we'll be deciding in your favor. It will be one of the factors. In decision making, several factors figure. It will be one of the factors, which may go in your favor, which may not go in your favor. Ultimately, because on points of law, matter is argued. This is a matter where judgment can be written either way, which Oliver Wendell Holmes used to do. He will write 2 judgments and he will not be in a position to know which judgment should be pronounced. He will ask his friends, I will not say the gender, he will ask his friends to choose one of them, and the next day it becomes law of America.
Nowadays, my lord, they're saying AI is developing so much that if you're given all the details, it can throw you 2 or 3 options. And the judge can then choose one option and say, this is the most correct option.
Also.
I submit, my lord.
Yeah, argument.
I am not arguing, my lord. I'm not arguing anymore.
May I make one submission, my lord?
Yes, sir.
Before your lordship closes the file, kindly have a look at para 53, 54, and 55 of Matthew Varghese case, compilation number 15.
Notes page number 15 in the compilation.
Submissions made by learned friend, Mr.
15.
Page 15.
15 to 55.
Which one? Which compilation?
First compilation.
That is Matthew Varghese 2014, 5 SCC 610, para 53, 54, and 55.
That's running page 48 minutes if I were to assist your lordship.
48.
Running page ನನಗೆ.
Ink page 48.
Keeping the said basic principle in
Number
applying.
15.
Keeping the
Citations of the petitioner.
All right, Odi.
53.
54 and 55. Which will help your lordship to buttress the arguments advanced by
having pronounced legal position as above.
No, it starts from 53, my lord.
53. We therefore.
May I read, my lord?
All our senior advocate ಓದ್ಕೊಂತಾರೆ ಕೇಳ್ರಿ ಅವರು. All right, ಓದಿ.
We therefore hold that unless and until a clear 30 days notice is given to the borrower, no sale or transfer can be resorted to by the secured creditor. In the event of any such sale properly notified after 30 days, clear notice to the borrower did not take place as scheduled for reasons which cannot be solely attributed to the borrower. The secured creditor cannot effect the sale or transfer of the secured asset on any subsequent date by relying upon the notification issued earlier. In other words, once the sale does not take place pursuant to a notice issued under Rule 8 and 9, read along with Section 13.8, for which the entire blame cannot be thrown on the borrower, it is imperative that for effecting the sale, the procedure prescribed above will have to follow afresh as the notice issued earlier would lapse. In that respect, the only other provisions to be noted is sub-rule 8 of Rule 8, as per which sale by any method other than the public auction or public tender can be on such terms as may be settled between the parties in writing. This is what the private treaty may allowed. As far as sub-rule 8 is concerned, the parties referred to can only relate to a secured creditor and the borrower. It is therefore imperative that for the sale to be effected under Section 13.8, the procedure prescribed under Rule 8, read along with Rule 9.1, has to be necessarily followed, inasmuch as that is the prescription of the law for effecting the sale, as has been explained in detail by us in the earlier paragraphs by referring to Section 13.1, 13.8, and 37, read along with Section 29 and Rule 15. In our considered view, any other construction will be doing violence to the provisions of the SARFAESI Act, in particular Section 13.1 and 8 of the said Act.
I want to make one last submission.
See, once the auction is failed, my lord, and the bidder fails to make the payment,
55 also.
the notice stands lapsed automatically.
My learned friends can allow me, my lord. I have one last submission to make, if they allow me. Lord, a sales certificate cannot be challenged separately.
It's a measure.
The measure, my lord, now again, my learned
Can
friend
be challenged, my lord. Ashok Samal's case, that is also filed by me.
1 second, sir. Sir, let me complete, please. Now, allow me. I have not said anything till now. You're all interrupting every single time. Lord, I want to make this point.
When going against him, he says, I am interrupting him.
ಏನಾಗ್ತದೆ ಲೈನ್ ಆಫ್ ಥಾಟ್ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತದೆ.
My lord,
ಸೆನ್ಸಿಬಲ್ ಮೆಂಬರ್ ಆಫ್ ದ ಬಾರ್.
The case itself is
I've
sensitive.
kept quiet, my lord. Every single time I kept quiet, sat down quietly.
Yes.
Now allow me to 5 minutes.
Now we will have your field now.
For explanation to your submission.
Yes. Why are you?
My lord, I sought permission from your lordship. Let him do, my lord. Let him do.
ಒಂದು ಏನಾಗ್ತದೆ, ಒಂದು ಥಾಟ್ ಪ್ರಪೋನ್ ಮಾಡುವಾಗ ನಾವು ನಡುವೆ ಫಸ್ಟ್ ನಾವೇ ಅವ್ರಿಗೆ ಟ್ರಬಲ್ ಕೊಡ್ತೀವಿ. ಐ ಶುಡ್ ಟೆಲ್ ಯು ಒನ್ ಸ್ಮಾಲ್ one second. Listen, one incident I am quoting in the life of Palkiwala. Palkiwala and Daptari was absent, and therefore Palkiwala was arguing before a 9-judge bench. And every time judges started asking the question.
Keshwanand.
Before he answered,
Keshwanand.
a 13th judge.
13.
And Palkiwala was fed up with judges like us, as you are. So, therefore, evening he went.
No, it's only a momentary reaction, my lord, because I too want to impress upon the court with.
Bidtana illa ನೀವು. You are talking over and over. You should learn to stop somewhere. So Palkiwala explained it to Daptari, saying the judges started putting question after question. I could not argue the matter at all. Then Daptari met one of the judges in the
Chief
wing,
Justice.
not one.
He met the Chief Justice.
Chief Justice.
He met the Chief Justice.
And said, yesterday the arguments went so well. My granddaughter was saying, who is this short man who was disturbing the argument of the judges? Then he realized much argument was by the judges only. Therefore, ಸ್ವಲ್ಪ ಸಮಾಧಾನವಾಗಿ ನಾವು ಮಾಡ್ಕೋಬೇಕು. ನಮಗೂ ಅದು ಇನ್ಫ್ಯಾಕ್ಟ್ ನಮಗೆ ಹೇಳಿದ್ದು ಜಡ್ಜ್ಗಳಿಗೆ, ಅದು ನಾವು ನಿಮಗೂ ಹೇಳ್ತೀವಿ. ಈಗ ನಿಮ್ಮ ಪಾಪ ನೀವು ಎಲ್ಲರೂ 3-4 ಜನ ಸೇರ್ಕೊಂಡು ಆಲ್ ಬ್ಯಾಟರಿ ಆಫ್ ಲಾಯರ್ಸ್ ಆರ್ಗ್ಯೂಡ್ ವೆರಿ ವೆಲ್. ಓಕೆ, ನೌ ಲೆಟ್ ಅಸ್ ಸಿ ವಾಟ್ ಹಿ ಸೇಸ್. ದೇರ್ ಮೇ ಬಿ ಅನದರ್ ವೀವ್ ಆಲ್ಸೋ, ವಿ ಡು ನಾಟ್ ನೋ. ದೇರ್ ಇಸ್ ನಥಿಂಗ್ ಲೈಕ್ ಇದಮಿತ್ತಮ್, ದಿಸ್ ಈಸ್ ಫೈನಲ್ ಅನ್ನೋ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. ಇನ್ನೊಂದು ವ್ಯೂ ಸಿಗಬಹುದು. ಅದಕ್ಕೆ ದಯಮಾಡಿ ಅವ್ರಿಗೆ ಒಂದು ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡಿ.
Supreme Court says certificate can be challenged.
We are right because we are
37 Ashok Sawmill's case. Let him make some. I'll clarify.
I said not 2 bites of the cherry.
ಕೂತ್ಕೊಳ್ಳಿ, ನೀವು ಕೂತ್ಕೊಳ್ಳಿ, ಸ್ವಲ್ಪ ಸಮಾಧಾನ ಆಗಿ ಕೂತ್ಕೊಳ್ಳಿ. Sit down.
There can't, when I said I started, Lord, I didn't complete the point.
That's what
I said. There can't be 2 bites of the cherry. The measure, my lord, is sale. You can challenge the sale. You have challenged the sale. You withdrew, my lord, the challenge to the sale. If you don't challenge the sale, wait till the sale certificate, you can challenge the sale certificate at that point in time after the conclusion saying some procedure has not been followed properly. But you cannot first challenge, lose there, and then come back again and challenge the sale certificate for the first time. That can't be done. My only point, my lord, is at any given point in time, you can challenge once. You can either challenge at the time the sale notice is issued, saying you cannot conduct the auction, then whatever is the consequence will follow. Or you can wait until the sale happens, then go and say this entire process is wrong from the beginning till now and challenge the sale certificate as one of them. But it can't be twice. Having lost the first time and the order not by having been withdrawn and you not having taken any steps, when it was told to you that that your discharge of liability is wrong by the DRAT, you should immediately moved an application to recall that order because your first challenge was subsisting. You did not do so. You just let it pass, went off in the writ petition, lost there as well, didn't take it any forward, and that was the end of the issue. Therefore, then you cannot come for the second time and challenge the same process which the bank is taking. That's the only point I wanted to make.
Notes, I'll just clarify this, minutes. There are 3 circumstances when secured creditor is entitled to, the borrower is entitled to come before the DRT. Lords, may kindly see under Rule 8.6 and Rule 9.1 is the first mandate, which is issuance of notice. Matthew Varghese case, Rajiv Subramaniam's case covers the first part, whether the notice under 8.6 and 9.1 is mandatory or not. It is not necessary for the sale to take place. If the notice itself is not issued for the purpose of bringing the property to auction, Matthew Varghese stopped at that. Said that if you have not complied with the mandate under Rule 8.6 and Rule 9.1, then the sale cannot proceed. So therefore it is set aside. This is the first circumstance. 2, notes, a person is required to deposit 25% of the amount within that, on the immediate day or on the immediate next day. He does not deposit that 25%. Notes the law which was standing earlier. I just wanted to bring this to your lordship's notice. Notes, if you kindly have a look at that Surface Act, notes, very interesting thing happened. Notes, a division bench of the Madras High Court said forfeiture should be to the account of the borrower. The interpretation which was placed on Rule 9.3 was, 9.4 was that 25% if a person does not pay, that 25%
account of the borrower.
Account of the borrower. So what the parliament did, it amended the provisions of 9.4, said that no, it will go to the account of. This is what came up for consideration in Shanmugh Velu's case. So now just what I wanted to submit is that if you don't make the deposit within 25 days and subsequently if the bank proceeds to accept it, let us say after 5 days, 6 days, that is the second cause of action. Now the third cause of action arises when 75% of the remaining amount should be paid within a period of 90 days, maximum period, which is permitted by the authorized officer of the bank. Let us assume they accept it after 2 years. That gives a third cause of action. You know, at every stage, every step is a measure which is referable to section 13.4. Section 17, therefore very expressly guards. If your lordships were to see section 17, it speaks about every step and the rules, following of the rules. So at every step, because this is a process. First it will be a notice will be issued under 13.4. Symbolic possession will be taken. Thereafter, physical possession may be taken. There also, there is one catch in this matter. 13.4 says you can either take over the management or just simply sit or take the property as it is. Because in cases, where let us say running industry. Now, if they just come shut down the industry and take the possession of the property, the inherent value of the property is completely lost. There, again, that is one of the measures which is provided for under 13.4. Not to say that at one stage when the first bidder did not deposit or the sale notice itself was vitiated because of 8691 would not spill into an adjudication of another cause of action of Rule 9.3 and Rule 9.5. So there is a lot of difference, my lords. Cause of actions are entirely different.
With my lord's permission, kindly see in page 13 of my citation in Ashok Sawmill's case.
Where
That
sale can
is
be
clarified,
challenged.
yes.
Certificate can be challenged.
Yes, sale certificate.
One paragraph I'll read, my lord. The intention of the legislature is therefore clear that while the banks and the financial institutions have been vested with the stringent powers for recovery of their dues, safeguards have also been provided for rectifying any error or wrongful use of such powers by vesting the DRT with authority after conducting an adjudication into the matter to declare any such action invalid and also to restore possession even though possession may have been made over to the transferee. Para 37. The consequence of the authority vested in the DRT under the subsection 3 of section 17 necessarily implies that the DRT is entitled to question the action taken by the secured creditor and the transaction entered into by virtue of section 13.4 of the Act. The legislature, by including subsection 3 of section 17, has gone to the extent of vesting the DRT with the authority, even to set aside a transaction, including a sale, and to restore the possession to the borrower in appropriate cases. Resultantly, the submissions advanced by Mr. Gopalan and Altaf Ahmad that the DRT has no jurisdiction to deal with the post section 13.4 situation cannot be accepted. This is what the Supreme Court says. Therefore, the contention is sale certificate cannot be challenged. Ashok Sawmill's case, my lord.
Ashok Sawmill's case.
It is citation number 3, 2014 SEC.
Flap hakidi. Paragraphs.
Paragraph 36 and 37.
Write down.
Yes.
Third result.
Grateful, lords.
Actually, I will be permitted to file dates and events.
Dates
and events.
ಅಲ್ಲಿ ಸ್ಯಾಂಕ್ಟಿಟಿ ಆಫ್ ಆಕ್ಷನ್ ಪ್ರಶ್ನೆನೂ ಇದೆ. ನಾಳೆ ಈ ರೀತಿ ಮಾಡ್ಕೋತ ಹೋದ್ರೆ ನಾಳೆ nobody will come forward for participating in the auction also. That's also there. The sanctity of auction. ಅದನ್ನು ಉಳಿಸಬೇಕಾಗ್ತದೆ. ಸುಮಾರು ಈ ರೀತಿ ಹಾಕೋತ ಹೋಗ್ಬಿಟ್ರೆ nobody will come forward saying that no ಇದೆಲ್ಲ ಮತ್ತೆ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ತದೆ ಏನಾಗ್ತದೆ ಬೇಡ ಕೊಡೋದ್ರೆ ಅರ್ಧ ರೇಟಿಗೆ ಕೇಳೋಣ ಬಂತು ಇಲ್ಲದ್ರಿಲ್ಲ. That may affect the public interest also. Anyway, let us see.
And
Lords, this is exactly the question considered in Celir LLP, my lords.
Correct.
And before,
it says the sanctity of the auction proceedings is one thing. The auction itself is a distress sale. That means a party is in distress and therefore we are selling. So by conducting an auction, you should not put the party into further distress. But in this process, the borrower's interest should be protected.
And before concluding, my lord, I had checked up with the client. As directed, he will ready to pay that 1 crore also, not an.
ಡೈರೆಕ್ಟೆಡ್ ಅಂತ ಯಾಕೆ ಹೇಳ್ತೀರಿ ಅಂತ
I'm sorry,
As suggested, as
ಇದೆಲ್ಲ ಜನ
suggested.
ಓದ್ತಿರ್ತಾರೆ
As suggested.
ಆ ಶಬ್ದಕ್ಕೆ ಒಂದೊಂದು ಅರ್ಥ ಇರ್ತದೆ ಏನೋ ಒಂದು.
I do understand. Slip of the tongue, man.
ಇದನ್ನ ಹಾಕಿ ಮೆಮೊ ಹಾಕಿ
Right.
ಮೆಮೊ ಕೊಡಿ ಮೆಮೊ ಹಾಕಿ ನೋಡೋಣ ಅದು ಇಟ್ ಆಲ್ಸೋ ವಿಲ್ ಬಿ ಒನ್ ಆಫ್ ದ ಫ್ಯಾಕ್ಟರ್ಸ್. ಜಸ್ಟಿಸ್ ಮಾಡುವಾಗ ನಾವು ಮಲ್ಟಿಪಲ್ ಫ್ಯಾಕ್ಟರ್ಸ್ ಅನ್ನು ಇಟ್ಕೊಂಡು ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಬರೀ ಒಂದು ಲಾಕ್ಕೆ ನಾವು ಜೋತ್ ಬಿಟ್ಕೊಂಡು ಎಲ್ಲ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಲಾ ಈಸ್ ಒನ್ ಆಫ್ ದ ಮೇನ್ ಫ್ಯಾಕ್ಟರ್ಸ್. It's what idea of justice by Amartya Sen says.
In various other judgments, only on the question, when it comes to refund, Supreme Court is directed at 12%.
12%.
That's what the direction seems to be. Although I'm not making that request,
No, I'm only pointing out.
I'm only pointing it out because my instructions
You
are
are most
we want to
erudite.
argue.
Most erudite of the senior advocates.
It's very kind, my lord.
Yes, I know that. And very sobriety. Never you cross your limits. One thing. Very sobriety means
I'm grateful.
Just one sentence I wanted to say, my lords. Justice should be done, of course, is the basic tenet of the rule of law. But your lordships have increased this to a higher pedestal to say justice should also be seen to be done. It should be felt that there is some real justice, which is not merely deciding a case with the laws applicable.
Temper with equity.
It should be there. I would not say, it's not merely procedural I'm speaking about, but in terms of the final outcome, whatever lordships feels is the justice which should be felt by the parties is what is justice seem to be.
Justice ಆಗಿದೆ ಅಂತ ಅನ್ಸ್ಬೇಕು.
My lord, I want to make one submission. My lord, justice must also temper with equity because I am a guarantor. Though definition may include borrower, may include guarantor. Please have pity on this and also examine it in that angle.
All right.
Borrower is the company of the guarantor. Borrower is the company. The guarantor is the shareholder of that company. And therefore, mortgages is property. Nothing more. It's the same alter ego.
Very good. Thank you.
I'm very grateful.
I learned so much of banking law. Thank you so much.
Highly
Grateful, lords. Grateful.
ಅದೊಂದು ಮೆಮೊ ಒಂದು ಹಾಕಿಡಿ. We will consider that also. It may be one of the factors.
By hand,
Yes.
we are writing in.
ಕಳ್ಸಿ.
Scene number 12 for final hearing, Government Advocate Giri Kumar.
Yes.
I made a mention in the morning for
Huh.
short accommodation. Anytime next week, Malaj, all the matters we are ready.
2 weeks. 2 weeks. Scene number 13, Raghu, yes.
For the respondent in this matter, my lord.
Yes, Raghu.
My lord, Mr. Counsel had informed me in the morning that he was not keeping well.
Not well.
Or inform ಮಾಡಿದ್ರು phone ಅಲ್ಲಿ.
Asked. Call after 2 weeks on the health ground of arguing counsel for the petitioner.
Much.
Scene number 16, Tirumalesh. One time.
All right.
16. Scene number 17, Naveen Kumar. C.R. Raghavendra.
Yes, sir.
Lordship,
Yes, sir.
I have challenged the order of the learned single judge granting reimbursement of GST in respect of a contract which is entered post GST. Tender is also post GST, and the contract says inclusive of taxes. That is the issue involved.
How courts have answered this question?
There are a few courts which have said that this cannot be a subject matter of writ jurisdiction because it involves interpretation of the contract and the intent of the parties.
So where they should go? Civil court?
Yes, Lord. Arbitration or civil court?
Arbitration clause idea?
Lordship?
Is there
Yes, it is
arbitration
there.
clause?
It is there. It is there.
If that is the only question, it's a pure question of law. Facts are not in dispute.
There are disputes on facts also as to what is the rate which has to be reimbursed. Once the agreement says inclusive of taxes, then what is the rate which they are claiming now? Because when the agreement was signed, it was signed with their eyes wide open. GST was already there. They knew the rates, but the contract said it is inclusive of taxes.
Let us see how the judgment reads.
Lordship would see at page 25.
Is it the your client, is it a state under Article 12?
Yes, your Lord.
No, that question will not arise. Yes. Tell me.
Yes.
Few foundational facts.
There were two contracts which were awarded. The tenders was floated in 2018, and two contracts were awarded in 2018. One was a renovation of swimming pool, and another one was operation, maintenance, and rehabilitation of park, Mahatma Gandhi Park. Lordship may kindly see the agreement. I would just request your Lordship to kindly see the clause relating to taxes. Because the GST law came from 1/7/2017. There are certain agreements in respect of other parties where the agreements were entered into pre-GST, which continued even GST regime. Those type of matters are also there. But in this case, your Lordship, the agreement was entered into post-GST only. Your Lordship would see clause 39.1. Can I read it out, Lordship? The rates quoted by the contractor.
Page number?
Page number 120. Clause number 39, your Lordship, 120 page. Lordship have it.
The rates quoted by the contractor shall be deemed
To be inclusive of the sales tax, labor welfare cess,
and other
other taxes. I'm emphasizing on that. That the contractor will have to pay for the performance of this contract. The employer will perform such duties in regard to the deduction of such taxes at source as per applicable law. So these other taxes, in fact, learned single judge has gone on the basis that it covers only sales tax. This other tax has not been considered in the order.
Which are other taxes?
Other tax will include GST also,
Is
which
it
came
you?
from 1/7/2017.
My lord,
Not true.
sales tax is subsumed in
The GST itself. Therefore, that question will not arise.
Please see that clause, my lords. I will not say anything. Let him continue, but what has to be said is this.
I will come to you.
Yes.
We'll come to you. How is your health now? Are you all right?
I am able to argue.
It's all right. Yes. Yes.
Lordship would also see
All other taxes are subsumed in GST concept itself.
Yes. Because when GST came, the all the state taxes, sales tax, entertainment tax, luxury tax, so many taxes were subsumed. Similarly, central taxes,
Correct.
like service tax, central excise, all these taxes were subsumed.
Therefore,
Now
this
when the
clause will not remain at all.
Lordship,
The other taxes concept,
yes.
that withers away.
Since it says other taxes, it would include GST also. It cannot be interpreted to say that GST was not considered in the agreement.
What is that clarification which the learned single judge has
Yes,
mentioned at para 11?
Yes. So that clarification, your Lordship would, that is in respect of those cases where the contracts were entered into prior 1/7/2017, when GST was not there. Old contracts, which continued after the GST came. In that context, there was a clarification issue, Can I request your lordship to kindly go to
Page
256, your lordship? Before that, can I request your lordship to kindly see, there's one letter dated 3/1/2020,
page number.
page number 195.
195.
Yes, your lord. It is addressed to Managing Director, Hubballi Dharwad Smart City, at page 195, lordship.
Clarification regarding GST.
Yes. With reference to the above, your request for clarification on tax calculation for the pre-GST period and post-GST period in the running bills of works has been examined by so-and-so and has suggested the following procedure for calculating taxes for pre-GST period and post-GST period.
Both are
As-
covered.
Yes, because those agreements were entered into before the GST came. Whereas this agreement is entered into only during GST, when the GST was already there. So therefore, this clarification issued will not apply to the present context at all, because that deals with ongoing contracts.
So post GST?
Post GST, it's an inclusive contract. So the question of renegotiating the price or making a fresh bargain by filing a petition does not arise. That is my respectful submission. So learned single judge, as your lordship asked me, goes on the basis that the agreement covers only sales tax. These other taxes has been lost sight. Second thing is that this clarification deals with pre-GST contracts, where they did not envisage that GST will come from 1/7/2017. Therefore, this clarification was given to say how to calculate the taxes.
But this has been given a post GST only.
It has been given because all those contracts were going on. In fact, in respect of many matters, this issue has arisen, and therefore this clarification was issued. So there are so many types of contracts which are happening, particularly works contract, post GST. Therefore, they came out with this clarification. So my respectful submission, lordship, is that this clarification would only cover ongoing contracts which are there. In a case where a fresh contract is entered, where GST was already there, known to them, there's no surprise element. Therefore, the question of applying this clarification would not arise.
That's the only point.
Yes, your lord. Lordship wanted to see the arbitration clause. Can I request?
Yes, sure.
Yes, sure. Page number there's one agreement. Page 125, your lordship would see the arbitration clause.
Indian case ಹಾಕ್ಬೇಕು ಆ papers ಗೆ. Page number
125, lordship. Clause 4 there.
Yes.
All disputes arising out of or in connection with this contract not settled by amicable settlement shall be finally referred to the Deputy Commissioner of the district. Upon such reference, the DC shall attempt to amicably resolve the dispute within 60 days. If the dispute is not settled, the first appeal shall be referred live with the Secretary, Urban Development Department, Government of Karnataka, who shall be the sole arbitrator.
Now this will go because of the apex court decision. It cannot go now to the authorities at all.
I was going through that judgment yesterday night.
Yes.
There, in fact, the Honorable Chief Justice applied the constitution principles also to say that it has to be looked at from that angle, Article 14 and all.
Correct.
The other two judges, Justice Rishikesh Rai and Justice Narasimha, they had a dissenting view and said that the contract, the Arbitration Act itself provides for a remedy to take care of it. Therefore, the constitutional principles should not be applied. That is the basis on which they have provided. Because it's,
No, the apex court say
yes, sir.
the arbitration shall not be before the authorities, designated authorities.
Yes, yes.
No, they only
That is the
say,
law.
Lordship,
I'll place it before you.
That's what.
the apex court
But we
said,
need not go that far, my lords. Let him finish. We need not go that far.
the apex court only says that the clause which talks about unilateral appointment, because in two cases which are referred, the managing director himself will become arbitrator.
That is a.
So a rule of bias.
Suva judex versus something, there is a
Yes,
principle,
yes.
no?
So
On
on that
means
basis,
one
they
cannot be
said,
judged in his own
but
cause.
the other two judges have observed in that judgment that just because there is a unilateral clause, it doesn't mean
No,
that.
which judgment you are saying? I think
Bench.
that is by larger bench. Now,
Yes, yes, that is three judges.
not three, perhaps a five.
I will just check that.
Not company.
Constitution.
Constitution bench judgment.
I will just,
Huh?
It's a railway case.
Correct.
core, CORE.
Core.
Electrification,
It's a constitution bench.
CERC.
Majority.
I will look at it. So my submission, Your Lordship, is that since the agreement was entered into post GST,
No, that you have said no.
yes.
If
And
you want to
can I-
prove it,
can-
well and good.
I have also relied on certain judgments. I want to place it on record where the honorable courts across the country have taken a view on this aspect.
Saying?
GST itself. One aspect is that they have said that the context of GST itself, there are judgments which say that since it involves interpretation of the contract, etc., it cannot be gone into in the writ jurisdiction. One set of case laws. The other thing is on the aspect of Section 64A of the Sale of Goods Act, because the Section 64A would say that was relied upon by them in the writ petition also. It says unless a different intention appears. So when the contract specifically says that it should be inclusive of taxes, then the question of applying the provision of 64A, etc., would not arise. So on this aspect, I have taken out few case laws. I would refer to few of them, Your Lordship.
Yeah.
Lordship, the first judgment is of Gujarat High Court. In the case of
Paragraph,
it is Bipson case.
Bipson surgical.
Yes, Your Lordship. Gujarat High Court.
Paragraph,
Yes, Your Lord. I'll come to that. The relevant findings start at para 9.1, page 8 onwards. I will just take Your Lordship to few paragraphs which are very important. Next, the para 9.3, Your Lordship, there. They abstract the clause and say, considering the aforesaid, can I read it out, Your Lordship?
yes, yes.
Considering the aforesaid relevant clauses and even the clauses mentioned in the rate contract, which were accepted even.
Inclusive of duties and sundry.
Yes. So then they went on the next page, Your Lordship, under the circumstances when the rate of contract, I'm reading the next page, was inclusive of duties, taxes, levies, and there is no clause for variation or price revision in case of revision of any tax, the petitioner shall not be entitled to change the rate contract, revision of price on any ground which otherwise is not permissible as per the terms and conditions of the tender document rate contract. At the cost of repetition, it is observed that as such the prices quoted as per the rate contract accepted by the petitioner suppliers was inclusive of all duties, levies such as VAT, excise duty, etc. And there shall not be any deviation permissible on any ground. Therefore, merely because VAT excise duty has been abolished, which was there at the 11th point of time when the prices were quoted and the rate contracts were executed and thereafter has been substituted by the GST, the petitioner cannot be permitted to change the rates and cannot be permitted to have the price revision. Otherwise, the same shall be contrary to the terms and conditions of the relevant tender documents rate contracts. It is required to be noted that as such, so far as the petitioners are concerned, they will have to pay to the government the same price which was quoted by them and as per the rate contracts which otherwise they agreed to charge. The next paragraph. The aforesaid issue is required to be considered from another angle also. As observed here and above, earlier and pre-introduction of GST, CGST, and as per the rate contracts, the liability to pay the taxes includes the VAT and excise duty was upon the suppliers. That at the relevant VAT time, the VAT liability was 5% and excise duty liability was 2%. As per the GST, now the tax liability would be 12%. For example, if the GST would not have been introduced and instead the VAT and excise duty would have been continued to be levied and the rate of VAT and excise have been increased, and take an example, the same increase to 12%. In that case, as per the
There
original.
was clause 49. Where is corresponding clause in the waiver contract?
Yes, Lord. I will just take your lordship. There's one clause regarding the price adjustment
Yes.
at page number 120. Page 120, your lordship.
Kindly come to page 8 of your Gujarat judgment.
Yes, sir.
Running page 8. 9.2.
Yes, Lord.
Ah.
While considering the aforesaid main issue, the relevant clauses of the tender documents and the rate contracts are required to be.
Come to second class.
Yes, sir.
Subclass.
The claim of revision of.
No. Clause 49.
Yes. The claim of price revision of finished goods under any pretext or reason, including the revision of duty excise costs, will not be allowed at any stage after the last date of submission of the tenders.
And above that.
Yes, sir.
Clause 13B.
13B. The rates quoted should be FOR destination anywhere in Gujarat basis, irrespective of value of order and inclusive of all charges such as packing, delivery, insurance, inspection, etc. per unit of packing as shown in the inquiry document. The rate shown against the item shall be presumed in all cases as the net price inclusive of all duties and sundries. No payment against any duties, delivery charges will be considered under any separate heading under any circumstances. Octroi exemption certificate, commercial tax deform for as applicable will be provided by the purchaser on such request from the tenderer after order has been placed by the concerned authorities. Tenderers will also have guarantee for regular and timely supply of all the items.
There is such a condition in your
Lordship
contract.
may kindly come to page number 120. Immediately after the tax clause, there is a clause regarding price adjustment.
120.
Yes, Lord. Same page which I showed earlier. Under what circumstances the adjustment is possible is mentioned here. 40.1 I will read.
Yes.
Contract price shall be adjusted for increase or decrease in rates and prices of labor, material, fuel, and lubricants in accordance with the following principles and procedures and as per formulae given in the contract data.
No, that will not applicable. What applies to you is 39.1.
Yes, your lord. No, after that, there's one more clause which is important. 40.2, because each contract they articulate it in a different manner. Apart from 39, 40.2 would say, to the extent that full compensation for any rise or fall in costs to the contractor is not covered by the provisions of this or other clauses in the contract, the unit rates included in the contract shall be deemed to include amounts to cover the contingency of such other rise or fall in costs.
No, cost is different.
Cost would include tax cost also.
But there is a separate clause.
Yes, it has to be read together. That means only under limited circumstances, there is an alteration which the contract provides. But in a case where the tax is involved, it has to be read with 39. Therefore, once the price is treated as inclusive of taxes, which obviously would include GST.
39
Yes, Lord.
is special provision.
Yes.
The other one which you have read, 40.1,
Yes, Lord.
is a general provision.
Yes.
As between special provision and general
Special
provision, even in contract, you know,
Yes.
the special provision will govern the rights of the parties. This is 39 is with the heading it is tax.
Yes.
Then how Gujarat judgment is applicable to you?
That is because the rate includes taxes. So there is no question of extra claim.
No, but that is here.
Yes, Your Lord.
Separate component is there. A separate clause is enacted.
No, the
between
amount which is quoted as a price would include taxes. Here they are claiming it as extra amount.
The rates quoted by the contract shall be deemed to be inclusive of the sales tax, the labor welfare cess and other taxes that the consumer will have to pay for the performance of this contract. Employer will perform such duties in regard to the deduction of such taxes at source as per applicable law.
Suppose it said price plus taxes extra, then they are justified in claiming. But in a case where they say the price which is fixed
Includes
taxes, the question of further claim does not arise unless it is a case where I have entered into a contract pre-GST, ongoing contract. I did not envisage the GST will come.
So this is misconstrued by the learned single judge is your contention. He treated that price will not include a tax at all. Tax is your liability. And price, it is not his liability at all, is the premise.
Can I take your lordship to that particular para in the impugned order? It becomes very clear.
Very clear.
On what basis?
That's what. Now this judgment is structured on the premise contra 39.
Yes.
Yes?
Yes, sure. Great. Page 25, the impugned judgment starts. I will read from para 2 itself. Lordship has.
So that tax liability you could not pass on to you at all is your submission because of 39.
Yes. And there are judgments which say, although it's an indirect tax, nothing stops me because most of the government contracts, it says price inclusive of taxes. So there's nothing in law which can stop me from entering into such an agreement, although it's an indirect tax. There are judgments on that, including Supreme Court. I'll come to that. Para 2, your lordship, page 26.
Yes.
The petitioner submits that the respondent authority had invited bids pursuant to floating of tender and the petitioner was awarded the contract. It is further submitted that the rates that were finalized as per the bid documents included sales tax component at 5%. Now sales tax was there, other taxes were also there, that has been lost sight. It is to be noted that the tender and work orders were allotted to the petitioner on 7/12/2018 and 29/2
after GST.
Which is admittedly after coming into force of the GST Act. Next paragraph, the petitioner submits that necessary payment at the petitioner's end of the applicable GST being statutory requirement has been made and details of payment are as follows. They mention the amount. Para 4, the petitioner submits that after having paid the applicable GST, the petitioner has made representations on 1/8/2019 wide so-and-so and 27/2/2020 wide so-and-so, whereby the petitioner has called upon the respondent to release the GST amount. The request of the petitioner was taken note of by the respondent authority, which has sought for the clarification from Karnataka Urban Infrastructure Development Finance Corporation as per their letter dated 6/12/2019. The specific clarification that was sought is as to whether GST is required to be made good to the contractor, as it was only 5% of the VAT which was provided for in the contract. The KUI DFC, by their communication dated so-and-so, has opined as follows. With reference to the above, this I already read it out, your lordship. So it refers to a case of existing contracts. which continued after GST. In that context, the clarification was issued, but that has been wrongly applied to a case where the contract is post GST.
But it's, let's say, add the applicable GST on those items.
Yes.
Item number 4 in
Yes,
that
sir.
para 5.
Yes, that is because when they entered into contract, let us say it was in 2016 or 15, at that time GST was not there. So therefore they give a mechanism to take care of GST also, because at that time VAT was there. Whereas in my case, the contract is entered in 2018, much after GST came, and therefore the agreement also says inclusive of taxes. They knew very well. And others have also participated in the tender by referring to those rates. So it will be unfair to them also. Can I continue this paragraph?
Yes, yes.
Para 6, I will read. It is not in dispute that the respondent authority has sought for clarification from so-and-so. Communication has been made out to the respondent authority as per the letter dated so-and-so in terms as noticed above. Various other contentions are raised, including that the contracts have a dispute resolution clause, and accordingly any dispute relating to the rates or as regards to the assertion of the petitioner that GST paid by him is required to be made is a matter to be referred in terms of dispute resolution clause. However, the petition could be disposed of without recording any finding on such. So that aspect is not gone into at all. Then it is to be noticed that clarification on so-and-so by KUWFC is clear. 9. KUWSSB has sought for a clarification relating to implementation of GST in relation to performance of portions of contract after coming in. I am placing emphasis on that. That dealt with the situation of pre-GST contracts, portion of which is done now. The finance department, by its clarification dated so-and-so, has also opined that the tax difference ought to be calculated on each of the works and necessary steps to be taken to decide as to whether contract agreement needs to be changed. While making such clarification, the nature of reconciliation of tax paid in the pre-GST regime, as well as taxes as applicable to all taxes in post-GST regime, has to be taken note of. The methodology and impact of change of tax has also been referred to. This stand has been approved by Additional Chief Secretary to Government so-and-so. This clarification made in the context of an authority set up under statute and taking note of the clarification made by the KUIDFC. The respondent is required to act in terms of the clarification made. Further, insofar as tax component is concerned, as the contracts were entered into after coming into force, this is also recorded, Lord, of the GST Act, and in light of opinion expressed by clarification made on so-and-so, the respondent is required to make good the GST after adjusting the amounts of sales tax that was provided for in the contract entered into between the petitioner and the respondent. It is further to be noticed that the tax component is an independent component which the petitioner does not retain as profit and there's a statutory payment to be made. Looking into the nature of such payment of GST, the respondent is required to honor the same in terms of clarification dated so-and-so. The consideration by the respondent to be made within a period of so-and-so. This is how. So my respectful submission is that the clarification does not apply to this case. And that tax clause, which specifically say other taxes, has been lost sight.
It was only sales tax.
Yes. Sales tax. They only refer to sales tax. So it's a deemed to include sales tax, other taxes also.
Mr. Raghu, kindly come to page 120. That rates quoted, that is item 39, clause 39. The rates quoted by the contractor shall be deemed to be inclusive of the sales tax, labor, welfare cess, and other taxes. Whereas the judge proceeds on the assumption, only sales tax.
Then, my lords, should inquire. Why this contract which is entered into after the GST was introduced, almost 1.5 years later? Why does it talk of sales tax still? It could have said GST. I don't need to answer this, my lords. They have themselves answered it. Please come to annexure G1,
Page number 194.
194.
190.
The lordships sees rates which were announced are PWD rates.
With reference to above subject, this is to bring to your
Yes.
kind notice during the execution of the agreement with contract for civil.
216 PWD SOR was considered, which include 5% VAT.
Whereas with regard to the new PWD SOR issue.
Please see the date, 10
6/12/2019.
September 2019.
The rates including GST and GST considered for all the BOQ items
12.
is 12%.
When was this done?
10 September 2019.
This is what this single judge refers to, my lords. This is a letter written by the appellant saying that the PWD rates were not revised till 10 September 2019. My contracts are entered into 2018. They themselves admit that it is only 5% VAT which has been included. And that 12% rate which was increased later was not considered for the trade. In this context, only that clarification came from KU. What did they say, my lords? KUI DFC says, take 12%, deduct 5%, the differential you reimburse. That's all they say. It is in this context that there is a clear admission of fact that the PWD rates never included GST. This is the background in which action. May I continue, my lords, or should he still continue?
No, if he wants to, now he has answered that point. Anything more you want to say?
I will just respond to this particular thing. The fact that it is 5% or 15% or 12% will not matter in a case where the agreement specifically says it includes all taxes. So this will make a difference only in a case where the agreement says the taxes shall be extra. In a case where it says, suppose, assume for a moment, your lordship, in fact, that was answered in Bipson also. Assume for a moment that GST had not come. And also assume for a moment that 5% VAT had become 10. They could not have gone and they could not have gone and claimed that differential tax because that contract inclusive. On the same basis, in a case where the contract which is entered into post GST says that it is inclusive of all taxes, this will not make any difference because whether it is 5% or 15% or whatever, it has to be borne as per the intent of the parties. And they have signed the contract with their eyes wide open and they cannot later on make a fresh bargain. That is my respectful submission, Lordship. And the clarification which came specifically deals with the pre-GST contracts. They don't say even in respect of contracts entered into post-GST how to reimburse.
Therefore, my lords, the clause 39, the lordships looks again at clause 39.
Yes. The rates quoted by the contractor shall be deemed to be inclusive of the sales tax,
Sales
labor
tax.
welfare cess.
Other taxes means
Other
other than
tax.
sales tax. Other
Correct.
taxes means other, doesn't include GST. Because if it includes
Sales tax is
GST,
subsumed in
GST, how can they say other taxes includes GST when sales tax was subsumed in GST? It makes that clause unworkable. If other taxes includes GST, there's no question of mentioning sales tax because that was already subsumed in GST. They made this clause because they consciously knew that the PWD rates did not include GST. That is why they still insisted on including sales tax.
what is meant by other taxes according to you?
Would be
Other
any
taxes would include even GST.
No, how? GST is subsumed in other taxes. All other taxes are subsumed in GST only.
Lordship, when it says sales tax and other taxes, whatever taxes are subsistent on that day, which is
No,
in
just
force,
we want to know what
GST
taxes.
also. It can be GST.
It cannot be GST because see, then it cannot be sales tax because sales tax is subsumed in
Yes.
GST. It appears that way.
Because once they say other taxes.
Which
On
are
the
the
date
other
of
taxes?
signing, that is GST only. What else can it mean? It cannot be anything else.
Please read that sentence. Sales tax, labor welfare cess, and other taxes. So it's a completely different category. Sales tax is one category. Labor welfare cess is one category. This is a completely different category. And if they were to say that GST is included there, I don't need the sales tax.
Because
Need not
sales-
be-
what the other taxes means GST only, according to you.
Yes, Your Lord.
But then they
It
could have written this letter. How did they write this letter?
But clarification is issued.
That
by-
is because there are other contractors who have entered into prior to GST.
No, no.
What you have done to other contractors? Similarly circumstanced contractors.
My lords, throughout the state, reimbursement has been asked to be made. There are in any number of judgments across the country where government has taken a decision. When GST was introduced, the rates were increased from 5 to 12% and then to 18. Government took a decision, we will deduct the sales tax, add the GST amount. So the differential has to be reimbursed. This is a doctrine of fairness. Nobody envisaged the GST will increase from 5 to 12.
And your clarification is very, very clear. What you wanted to have clarified, that has been clarified.
And they deal with only pre-GST contracts,
That's what
not
you are
post-GST contracts. In fact, since your lordship asked that question, taxes, whether it includes GST or not itself is a disputed question of fact. So therefore, in fact, Kerala High Court rejected the petition on that ground. They said that itself can be a disputed question.
No,
of
we
fact.
are interpreting the document.
Yes.
Yes, your lord.
A document between a state entity and a citizen.
Then
Where is the question of leading evidence to that? You have to interpret the document.
Yes, your lord.
the other thing, my lords, is, was there a dispute? If your lordship sees, they have written a letter saying it should be reimbursed. There was no need to invoke the arbitration clause. Your lordship sitting singly, I'll just pass that. In one of the judgments specifically said, if there is no dispute, there's no question of arbitration.
If there is a
Chiranjeev.
dispute question of
There
arbitration.
is no,
all right.
yes, if there is no dispute, no arbitration. Here, they themselves have said it should be reimbursed. Where's the question of going to arbitration? Please, please see, my lord, Chiranjeevi versus State of Karnataka. Please. The lordship's records at page 2,
Did it not go in appeal?
not to the best of my knowledge.
Sorry. Whether this
Not to
matter
the
went
best
in
of
appeal.
Two propositions your lordships laid out is, one, that the government should act fairly being as Article 12 entity. 1, 2. And therefore, it's not a bar to entertain a writ petition. Then my lords will see what your lordships also said. Please come to page 3, the last H, 3H. my lords. At page 3. The vehement contention of the learned AGA appearing for the government and the learned panel council appearing for the corporation that there is an arbitration clause and therefore petitioner should be relegated to arbitration cannot be countenanced for obvious reasons. First, question of invoking arbitration clause arises when there is a true dispute between the parties. There being no contentious issue about the completion of the tender work and there being specific reports about satisfactory completion of the work. Petitioner cannot be compelled to go for arbitration on the basis of a make-believe dispute. Secondly, several representations of the petitioner resulted into a fully positive response from the side of the respondent corporation. Its managing director specifically asking the government to release the fund to enable him to honor the loan. Never the government took the pains to honor the long pending bills of the petitioner, etc. Here also, my lords will see, when I wrote a letter to them, they themselves admit that 12% has to be paid. There was no dispute. They asked clarification from the government. Government says, no dispute, reimburse. I am not able to see how this can go to arbitration. And even assuming it is there, doctrine of fairness also will apply. There is no dispute, no arbitration.
Any other point you want to see?
Lordship, I have also put the other case laws. If your Lordship permits me,
Yeah.
I would,
To the point,
yes.
in support of what proposition?
In fact, there was one more matter of Davangere Smart City. I am Hubli, the Dharwad Smart City. There, the Honorable Single Judge, Justice Shyam Prasad, he has taken a view that matter should go for arbitration. It is, I have not put it as a compilation because I saw the matter came up last week. Your Lordship adjourned the case because the other counsel had undergone some surgery. Can I just pass it on, Your Lordship?
Query.
In fact, I had asked the party to find out whether similar clauses are there. I was not very sure about because I do not know that counsel in person. But it is my duty to point out that there's something which came up last week also.
No appeal. It appears that no appeal is filed against that judgment.
It is pending, Lordship. The first page is the writ appeal. Probably the matter where he referred, your
It's
Lordship's
pending in appeal.
judgment, their appeal is not there, but this appeal is pending.
Which appeal? No. Shyam Prasad's appeal. Shyam Prasad's judgment.
Yes.
No, but my judgment has not gone in appeal.
No.
Number two, my judgment is not referred in this judgment.
Yes. But here, this is a GST matter.
No, that's all right. But when you sought for the same clarification, they said, yes, you have to give.
Yes.
Court judgment said, yes, give that.
Lordship, that is for the pre-existing contracts, not for post-GST contracts.
No.
If it is a case of post-GST contract and they give a clarification, then there is no case at all.
My lord, this is a post-GST contract. Please see the dates. I am telling again and again, my lord.
19 October 2019.
That was when the PWD rates were revised.
That is because this dispute was pending before various benches, because many people have filed petitions asking for reimbursement because the contracts were running from the past. So in that context, I had to write a letter. Matters have come to this court also. Some are pending before the learned single judge.
Yadav Saab has rightly considered. He could have written still better order. That is always scope for improvement even in heaven. That's what Oscar Wilde used to say. There is scope for improvement even in heaven. Even if we write a judgment, there is scope for improvement. Anyway, broadly agreeing with the reasoning of the learned single judge, intra-court appeal is rejected. First, refer to the ruling cited at the bar. Okay.
Deeply obliged.
Grateful.
For 18, Jivan J. Niralgi.
Respondents.
Yes, sir.
On behalf of Mr. Jivan J. Niralgi, he is on his legs. He has requested for some short time.
He is on his feet.
He's on his feet. He is arguing in that. He just informed.
Afternoon?
As convenient to the court.
Afternoon, Madhuda?
I'm ready. If my learned friend is ready, I'm ready.
Believe that.
Afternoon,
Monday.
Okay. Not the next week we'll have that.
Very well.
Yes. For long, you were not seen here in this court.
My lords, I've been trying my hands at other subjects of law.
Very wonderful.
I thought it's time to do something more and learn in the process.
That's what. There's one famous book by Lord Denning.
My lords,
That book is Beyond Law. I
Beyond.
think it's the lost book.
this is last book.
Things with the Beyond Law.
I would definitely love to.
Just
read.
look it.
Yeah, thank you. My lord. Great.
C number 19, government advocate.
Next week, all right.
C number 20, Tirumalesh.
Malaysidrala. All right, enable counsel for the petitioner to come and argue. 2 weeks.
21, government advocate.
Next week. Next week. Clock.
23, Venkatesh Sarbati.
Venkatesh was here. Just he peeped into and went, na?
I've informed him that I'll be taking time.
All right. 2 weeks.
C number 24, Hema Kumar.
I have to make the same submission. I apologize, my lord, I couldn't get ready
No,
because these are all revision petitions where I have to read.
you need not apologize. If you come
assessment-
next time with preparation, it is done.
I'll do, my lord, because revision petition, assessment order, first appeal order, second appeal order, ಮೂರು ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕು. I don't want to come unprepared before my lords.
Well, don't go before any lord also.
No, I'll not. Writ petition ಆದ್ರೆ ಹೇಗೋ ಒಂದ್ ಸ್ವಲ್ಪ ರೆಡಿ ಆಗ್ಬಿಡ್ಬೋದು. ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ
ಒಂದೇ ಮ್ಯಾಟರ್. 2 matters. ಒಂದೇ ಅದು. ಕಳಿಸಿ.
ಮುಂದೆ ನಿಮ್ಗಾಗಿತ್ತು. Next week. ಒಂದೇ enable. ಹೇಳಿದ್ದೀನಿ ಸಾಹೇಬ್ರಿಗೆ. ಅದ್ರಲ್ಲಿ click ಮಾಡಿ Two weeks.
ನಾವು ನೋಡೋದು ಪೇಪರ್ ತಿರ್ಗಿಸ್ಬಾರ್ದ
ಬರೀಬೇಕಾದ್ರಲ್ಲ ಅದೆಲ್ಲ ಅವ್ರದ್ದು. ಹಿಂಗೆ ಬೆಂಚ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಡಿ ಸಾಹೇಬ್ರಿಗೆ ಇನ್ನೊಂದ್ಸತಿ ಮತ್ತೊಬ್ಬ ಬಂದ್ಬಿಟ್ಟಾರ.
ಎಲ್ಲ ಚೆನ್ನಾಗಿ ಮಾಡಿ ಸೂಪರ್ ಆಗಿ
ನಾವಿರಲ್ಲ.